May I close it? I'm paying for listing my lord, one contempt case, my lord.
Sorry,
I'm paying for listing my lord.
praying for listing,
Yes, my lord. Contempt case.
contempt matter. Oh, yes.
May it please your lordship. Lordship may pray for listing of an IA for tomorrow, lordship.
What is
IA
the
has
matter?
been filed for extension of an interim order, and the writ petition has been listed tomorrow before this honorable court. Oblige your lordship.
Yes.
May I please your lordship? Lordship, in item number 13, we have filed an additional affidavit today. Kindly the records may be called, lordship.
Item 13, all right. Get it.
Much obliged.
May I please your lordship? Lordship, I'd like to mention item number 26 and 27. Lordship, there is some difficulty. Lordship, the matter may come after 2 weeks.
What difficulty?
Lordship, the conducting council is having some personal difficulty.
26, 27,
Yes, lordship.
adjourn for the day. Yes.
Okay.
Yes, Mr. Goswami.
Look, this matter has been heard extensively before another bench, whether you would like to take it up.
It is up to you.
And there is an order also, I believe, my lord, making it part heard before them. I don't know, I think, my lord, it's my duty to point it.
It is submitted by learned counsels for the parties that the matter was extensively heard before another bench. This is reflected from the order also dated 25/7/2023. Accordingly, registry directed to list the matter before appropriate bench.
Much obliged.
Lordship, my senior is on Lexington court number 1. Kindly pass over the matter for time.
Same prayer, lordship.
Same prayer. Why not close it?
Lordship, he is in Lex in court number 2.
Legs in court number 2. You argue? You were there? What is the matter about?
Lordship, I don't have the brief. I'm deeply apologize now.
You go through the second brief right now. We'll take it up. No adjournments. You ask for the court master will give you the second brief. Go through it. Yes. Yes.
May I please, your lordship? Lordship, senior counsel, you can will come till he comes. Lordship may allow me to place the facts.
What is
The
the matter?
matter
What is
pertains
the matter?
to appoint,
Yes.
my lord, matter pertains to appointment of teachers in lower primary and upper primary schools. Basically, the issue here is that, my lord,
Who's for the other side?
government, elementary education.
Elementary education. Where is elementary education? Who's for elementary education? Yes, please call him. Yes, please.
My lord. My lord, here issue is that basically the 18 months DLED course, the person having the 18 months DLED course was appointed arbitrarily by the advertisement at page 51. It starts from page 51, my lord, whereas the prescribed criteria is 2 years DLED, my lord. The advertisement starts from page 51 and the qualification is at page 53, my lord.
Advertisement is at
Starts from page 51 and the qualification is at page 53, my lord. My lord, got it? My lord, the table below,
Yes.
minimum qualification, essential qualification and experience. A, senior secondary or its equivalent with at least 50% marks and 2-year diploma in elementary education.
Why this education matter is here? Is this before this bench?
Yeah, because
This is education matter.
because the Honorable Justice Bujar Barua, he will not take up the matter as the AG was concerned, my lord.
Who's taking up bench two? Sabi. Civil bench को कोने लोग?
Bench to
Civil
লিখব
bench
পাৰে।
two.
আগতে AG appear কৰি আছিলে কাৰণে মানে তেখেতে সেই কৰিছিল তো not by কৰিছিলে। Earlier it was not by the Honorable Mr. Justice M. Bujar Barua, my lord.
Now it's before
Now-
court number 3. And
He is taking the bench to my lord.
file to petition now.
Three.
File to কথা কৈছে। 13 নম্বৰতে বুলি। এনে আহিলে কিলো লাভ নাই। এই side ত চাওঁচোন, side ত চাওঁচোন। সিফালে টিভিটো আছে।
এখন চাই লওক না ইয়াতে আছে। নাই নেকি এখন? Alright. Yes.
My lord. My lord, I'm referring page 53, my lord. The essential qualifications and experience.
Hmm. These are vacant posts of what?
Lower teachers of lower primary and upper primary schools.
Is it teacher or assistant teacher?
Assistant teacher, my lord.
All right.
My lord, the minimum qualification is senior secondary or its equivalent with at least 50% marks and 2-year diploma in elementary education. Here, in advertisement, it is specific that the requisite criteria along with the other criteria is 2-year diploma in elementary education, my lord. My lord, why they have appointed the person having 18 months DLED course? Their justification is that, my lord, the government has relaxed for in-service candidates.
Who are you? Who are you?
My lord, I'm the candidate, my lord.
You had applied for this?
Yes, my lord.
You had set for the selection process?
Yes, my lord.
You have the qualifications?
Yes, I have the qualification, my lord. I have the requisite qualification of 2-year diploma in elementary education, my lord.
Okay, then.
The relaxation was made basically, my lord, before coming to the relaxation, my lord, of 18 months DLED course, why the course has been relaxed for some particular candidates of in-service candidates to 2 years to 18 months. Why it was relaxed, my lord? Because in the year 2017, the RT Act was amended. Because of the RT Act amended, the person who were not the requisite criteria after 1st of April 2019, they will lose their jobs. If your lordship have a look at the amendment, my lord.
Yeah.
My lord, here, the RT Act of 2009 was amended. Number 1, This act may be called the Right of Children to Free and Compulsory Education Amendment Act 2017. It shall be deemed to have come into force from first day of April 2015. In the Right of Children to Free and Compulsory Education Act 2009, in section 23, in subsection 2, after the proviso, the following proviso shall be inserted, namely, provided further that every teacher appointed or in position as on 31st March 2015, who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children to Free and Compulsory Education Amendment Act. Means it was effected from 2015 for 4 years, my lord. Hence, within 2019, 31st March, they have to acquire the minimum qualification who are already in service teachers, my lord, who are not having the requisite qualification as per the NCT guideline, because as per the NCT guideline, the required qualification along with the other qualification is 2 years diploma in elementary education, my lord.
Yes.
And now, my lord, lordship, I will look at the relaxation part. The why the 24 years diploma was relaxed to 18 months course, my lord. My lord would get the order at 105, my lord, page 105.
105. Yes. Yes.
My lord. I'm reading from the top, my lord. Recognition order, my lord. Whereas the matter of recognition of the project proposal of National Institute of Open Schooling NIOS, NIOS, Noida for DLED program through Shyam Portal of MHRD for training of in-service untrained teachers, my lord. Teachers was considered by NRC and NRC observed as follows. And whereas the NCT has received directions from section 29 of the NCT Act 1993 and from the Ministry of Human Resource Development by letter number so and so. The project proposal for recognition of diploma in elementary education program through ODL mode has been submitted by National Institute of Open Schooling NIOS to NCT headquarters. The proposal is for conducting online DLED program through Shyam portal of the Ministry of HRD for in-service untrained teachers at elementary level working in government aided, unaided private schools in the country. Basically, this recognition order was passed. The course was relaxed because for the in-service, my lord, for the in-service untrained teachers at elementary level working in government aided and unaided private schools. The teachers who were serving in the government schools, private, even unaided schools, who were not having the requisite qualification, just to fulfill the mandate of the Right to Children Education Amendment Act and to save their jobs, my lord, this recognition, this relaxation was passed, my lord. Not for a fresh, our contention is that, my lord, not for a fresh candidate, my lord, not for a fresh appointment. This relaxation cannot be done for a fresh appointment, and the respondent authority has arbitrarily done it, my lord.
Yes.
If your lordship have a look,
Who has given this relaxation?
my lord,
Who has passed this relaxation order?
my lord, this relaxation order was passed by the NCT, my lord. National Council for Teacher Education. And in their reply, the NCT has stated that it is not for fresh appointment, my lord. In the affidavit filed by the NCT here, in this case, if your lordship have look at the affidavit filed by the NCT, my lord. Affidavit filed by respondent number 3. My lord got it.
How many posts were advertised? 5,393.
Yes, my lord.
So all have been filled up
All have been filled up.
by in-service teachers.
Not by in-service teachers. Some of more, some of in-service and some are fresh recruitment also.
Hmm. So why are you saying that this relaxation is only for in-service teachers for filling up?
Because my lord, here the order itself says it.
So,
The
but
recognition
you
order.
participated in the process.
My lord.
You participated in the
Yes,
process.
my lord.
Some candidates like you have been selected.
Yes.
You're not challenging their appointments.
My lord, why I'm not challenging it? Because in the advertisement, there is no criteria that they will relax the, they will relax the time period, my lord, from 24 to 18 months. Because in the advertisement, your lordships have a look again at page 53. There was specific, my lord.
What is the process of selection?
My lord, first we have to apply it online, then
Where is it specified in the advertisement?
my lord, criteria at page 52, my lord. My lord will get at page 52 criteria, my lord. The candidates will be selected for the post of assistant teacher in the same medium school as per the language one selected in the teacher eligibility test. Number 2, separate merit list will be prepared for each category as shown in table 1. 3, a candidate must not be less than 18 years of age and not more than 38 years of age as on 1st January so and so so and so. The eligible candidate shall apply online in the official website of DEE Assam from midnight so and so to so and will be accepted in this regard. The online applications and documents submitted by the candidates will be verified along with their original testimonials by the district level selection committee. The district wise detailed schedule and venue for screening verification of documents will be notified in the official website. No TADA will be admissible. And lordship may have a look also at page 55. Please note.
Hmm.
The said advertisement, last page, my lord.
Hmm.
After successful submission of the online form, candidates shall take a print out of the form and submit the same along with self-attested copies of mark sheets and certificates in support of educational qualification, caste, disability, TET, DLED, and co-curricular activities at the time of document verification before district level selection committee. Candidates should be cautious while submitting the online application form, as once the online application is submitted against a particular roll number of TET examination, they will not be allowed to submit the online application form for second time. These are the criteria, my lord, basically. And here,
What is advertisement B?
my lord, same, earlier was for lower primary and B was for upper primary, my lord.
You are challenging selection process to both.
Both, my lord.
You had
Because-
applied for both.
Yes, my lord.
And the same relaxation applies for upper primary
Yes,
schools
my lord.
also.
Yes. But there was no mention of any relaxation in the advertisement, my lord. Whereas, after filing this writ petition, they have issued another advertisement wherein they have mentioned it,
Mention what?
mentioned the relaxation part, my lord.
Hmm.
And my lord, if your lordship have a look at the affidavit filed by the NCT, my lord,
So what is the process of how the merit is to be adjusted? How it is to be decided?
my lord, merit is to be
There
adjusted,
is no written test.
no written test,
There is no interview.
no, my lord.
Then
It is based upon their educational qualification, my lord. The marks, they,
so where is it indicated? How many marks? What marks will be allotted?
please note at page 55, my lord,
Hmm.
the third bullet point, my lord. After submitting the online application form, the candidates will get a unique number against the submitted application and will keep the printout of the unique number for all future appearances. Candidates may note that failing to appear before the district level selection committee for screening verification of documents on the scheduled date and time will result cancellation of their candidature. No further communication in this regard will be entertained. The office will not be responsible for any lapse in submission of online application due to any technical problem. The following self-attested copies of certificates and documents to be submitted with the printout copy of the online application and original testimonials will be produced before the district level selection committee. Mark sheet, senior secondary, pass certificate, HS, senior secondary, pass certificate, HSLC admit card in support of age, certificate of mark sheet of TET for LPS, certificate and mark sheet of DLED, certificate in support of scheduled caste, scheduled tribe. Candidates with disabilities will have to enclose certificates of disabilities issued by COPS authority, certificate of NCC, sports or cultural representing state or nation, certificate of ex-serviceman issued by the director signing welfare board. Basically, here is that, my lord, the person who are qualified means, suppose if they need HS, the government, the department will scrutinize it from the ascending manner, and they will select the person who are more qualified, my lord, in the marks, my lord.
Hmm.
But here issue is that, my lord, most of the half of the posts were filled up by the persons who were not having the requisite qualification itself.
Hmm. Then? Yes.
My lord, if your lordship have a look at the affidavit filed by the NCT, my lord,
No, no. What is this? What is the writ appeal order?
my lord, the writ appeal order was, TET was not held. As the TET is a criteria for the appointment, my lord, TET was not held from 2011. That's why some candidates have preferred writ appeal, writ petition, which was dismissed, and thereafter writ appeal was preferred, which was allowed, and TET was held, my lord.
All right.
There is no issue about the TET, my lord.
All right. Then?
My lord, basically, we have applied it and we were not selected. That is the main grievance, my lord.
What is the stand of the government?
Our stand is that this 18-month delayed course by the NIS, it has been held by around 3 or 4. I've just gone through, my lord, even in December 2022, this course has been held to be equivalent to the normal DLED. And there were orders from the Honorable High Court to treat all those persons who underwent the 18 months DLED course as equivalent to those who underwent the 24 months DLED course and to allow them opportunity in recruitment, fresh recruitment processes. The affidavit given referred to of the NCT was at a point of time when these judgments were not on record and when the NCT, on the instruction of MHRD, had held that it was not equivalent. However, with the instructions coming down from the MHRD, now the NCT has decided to
Make
make
it
them to be
equivalent.
equivalent. The orders passed by the Uttarakhand High Court, my lord, in December 22 is now before the Honorable Supreme Court and is a pending matter.
What is that order?
My lord, that order, it was passed on December. I'll give the details.
To what effect?
Well, that these are equal. I'll just read the last paragraph, my lord. This was 14 December. We allow the writ petitions and hold that the 18-month DLED training diploma conducted through the ODL mode in elementary education by the NIS is a valid diploma for applying against the regular post of assistant teachers. The respondent shall therefore consider the candidature of the petitioners in the said post on the basis of the applications made by them pursuant to the advertisement issued by the Department of Elementary Education, Government of Uttarakhand, Dehradun. Petitioners shall be entitled to costs quantified at ₹2,000. Now, my lord, we had allowed these petitioners to participate because the certificate which was issued to them was a certificate which says that they had acquired the diploma in elementary education qualification. They were allowed to participate, their marks were taken into consideration. and the matter was processed and the matter has been finalized. Although the matter has been finalized, now, if this issue, as my lord, is reflected in the,
What is their position in the merit? What is the position of the petitioners?
that individual, I have to find out, my lord, they have to give us the application number, I can find out.
No, their grievance is perhaps that other similarly situated people were selected.
Huh.
But because of these in-service candidates, their share was taken up,
Yes, that is their case.
which means that had they scored, if it is their case that they have scored more than the in-service candidates, then they would ought to have been given preferences.
Not only difference, my lord, they would have, if they secured the merit, they would have been appointed.
So what is the merit? What is the cutoff mark?
So, my lord, if he just gives me the application numbers, my lord, it will take me.
So it is for you to satisfy the court. What application you have?
Because they have not stood in merit with those candidates, they.
That is what we are asking you. On what basis do you say they have not stood in merit? There has to be a merit list. There has to be a selection process.
Only with the names of the petitioners, my lord, it is difficult for us to find out from these thousands of applications, the few lakhs of applications, my lord. I'll need the roll number or the application.
You
number,
have
nothing else, my
taken
lord.
trouble to prepare a merit list.
Yes,
That
my lord,
merit
but I
list
must
will
have the
require some
detail-
scrutiny.
I will have to have their application number or the roll numbers. There might be 4 Dheeraj Kumars on the list, my lord. We do
Now,
not know to which district he has applied. And otherwise, my lord, the case in the Supreme Court is.
so we want to know what is the selection criteria? How do you select?
Well, the criteria is very simple. We take up all the numbers, the merits scored by them in the different examinations that lordship will find in the education manual itself, my lord. The
I think
method in which it is done.
reflected in the advertisement.
1977, in the advertisement, yes, my lord, it is there.
Is 54.
Yes, yes, my lord, page 54. Lordship will find at page 54, HSLC marks, the TET mark, the DLED mark, the NCC sports. These are the marks, my lord, and that is as per the rule itself, 1977 rules. These are the only criteria we can take into account.
So marks means how much marks do you
My
score?
lord, yes, my lord, that if lordship will kindly have the 1977 rules, my lord, for a moment.
77 rules.
My lord, yes. 77 provincial election act, my lord, sorry. The second 77. Yeah, provincial election rules. At page 293, my lord, starts at page 293. And lordship would find the marks which is to be given at page 308.
293.
293, 293 it starts.
Hmm. Then?
And at page 308. my lord. Selection of teachers for lower primary and upper primary schools shall be made on the basis of marks obtained out of total marks of 330 for lower primary schools and 430 of the upper primary schools, apportioned for general qualifications, professional qualifications, teachers eligibility test holding the certificate of NCC, sports, fine arts, and cultural activities as under. Credit for the marks secured in the higher secondary examination or its equivalent, 100 marks, which shall be directly proportional to the percentage of marks secured in the HS examination. Credit for marks secured in professional degree diploma in the DLED, BLED, B.Ed by whatever name known from a recognized university, 100 marks, which shall be directly proportional to the percentage of marks secured in the DLED, BLED, B.Ed examination. I just pause, my lord. This B.Ed part has recently been held in January 2023 by the Supreme Court that it will not be applicable for the persons who are applying for posts in the lower primary and the upper primary schools. It has to be DLED, it cannot be BL. Then, my lord, clause C, credit for marks.
And the petitioners have what? degree?
DLED.
DLED.
They have DLED. There's no difficulty. It's a clarification. At clause C, we have credit for marks secured in the teachers eligibility test examination 100, There will be no marks for Viva also, but however, 30 marks shall be awarded as specified below. 10 marks for NCC, 10 marks for participation in recognized.
So
sports
there's no
in national-
viva, there's no written.
Nothing.
Then?
They simply give the documents. We verify the documents at one stage when they are within the cutoff. We verify the documents on the basis of merit, select lists are prepared and they are allowed through.
What if candidates secure the same marks,
My lord, if the candidates secure the same mark,
more than one?
more than one. My lord. There is a office memorandum, perhaps not given here. There is an office memorandum which says that in that case, it would be the age criteria which determines it. That is what I had asked of them at one point of time. They had told me.
So your affidavit must disclose what is the stand in the merit.
Their status.
Exactly. Because there is no other criteria.
There is no other.
What is your explanation for not considering their cases for appointment?
My lord. It was at a point of time, my lord, when they had approached this honorable court.
Hmm.
At that point of time, the merit lists were not prepared. So then we could not have said that whether they would secure the marks or not. Results have possibly come. I'm sorry, the provisional select list is there, my lord, at that point of time.
Hmm.
I'll press out, my lord. Lordship will give me a week's time. Next week I'll have that. My application to ask me. You participated.
Yeah.
Can you give me the phone number that you give me? Give me half an hour. যদি আপনাকে রোল নাম্বার কিনে আনা if you can show it to another merit. দেখি না, আপনি দেখি না। Okay, no, I application for the okay.
Yes. On what basis do you say that your cases, you have a right to be considered over and above the?
My lord, basically on the basis of the advertisement,
Hmm.
because on the advertisement, in the advertisement, my lord, they have specifically stated the requisite qualification and which have not.
Mr. Mazumdar,
My lord.
the grievance of the petitioners is that their share of posts have been
Occupied by someone.
They say that those persons should not have been allowed to participate at all.
exactly.
They do not say that any of those persons have actually usurped their post or they have scored above any of the persons who came in with a 18 months DLA. They have not named anybody. No one is made a party here.
No, that's correct. But they will not have the access to the
They have
records.
it, my lord.
No.
The provisional select lists are published. That is what they
How
have
we
said.
can
The
have it, my
published,
lord?
the published select lordship will kindly have their fair portion.
In the provisional select list, my lord, there is no mention that who are having 2 years DLA course, who are having 18 months DLA course. How we can know that,
Will
my lord?
kindly have It is further prayed that pending disposal of this application, operation of the provisional select list dated 24/3/2020 may kindly be stayed. Now, if Lordship would unless if that is the argument that we have not even placed it on record, it would be upon them to show that someone has replaced them. Otherwise, they don't have a case at all.
No, their case is that you have proceeded in the selection process contrary to the terms of the advertisement,
Yes,
which you can't do. Unless you have a good reason.
The 18 months delay, not the advertisement,
The advertisement,
my lord.
the grievance, the specific grievance is that what the in-service teachers,
yes,
in-service teachers.
Yes.
In-service means what? Regular.
no, my lord. Maybe regular,
In-service teachers are those who are either
maybe regular,
serving-
maybe irregular.
They may be serving in private schools, they may be serving in provincialized schools, they may be serving in government
Government
schools,
schools even.
either as contractual or as regular teachers, because a person from the lower primary is allowed to apply for a post in upper primary. In the advertisement,
No,
we have,
no. Upper primary, I understand. In the lower primary.
but both require DLN. So a person who is on contractual basis in lower primary can apply for a regular service in the upper, in the lower primary.
What is
itself.
the meaning of serial or clause number 8 in
Eight of
page
the-
53?
My
The
lord.
regular.
The
teacher-
regular teachers working in LP school are not allowed to apply in any post in LP school. That is, if a person is working in as a regular teacher, that is a regular teacher under the government of Assam,
Hmm.
in any LP school, he will not be allowed to apply for a post of LP school teacher, regular post in any other district. He will not be able to go. Next, regular teachers workers in upper primary school are not allowed to apply in the upper primary school system because he is already a regular teacher there.
Hmm.
Our number of teachers then doesn't change. It is only they take an advantage of going from one district to another, one school to another.
But my lord, if he is
Next,
contractual
however-
teacher, he can apply.
A
my lord.
minute.
Sorry, my lord.
However, regular LP teachers, if otherwise eligible, may apply in upper primary schools through proper channel only. Next, all eligible contractual teachers may apply to any one of the posts. There is no difficulty. From contractual, if someone wants to become a regular teacher, that is allowed.
Hmm.
And the argument, my lord, that we have allowed that 18 months DLED course to come in, we had never restricted them.
Yep.
They are persons who hold a regular DLED certificate. They are certified by the competent authority, by the competent institute or by the NCT to be diploma holders in elementary education. So whether it is a 24-month course or an 18-month course, that differentiation was never brought into in the advertisement. A person who passes matriculation either with grace mark or without the grace mark, let us take the case. In our advertisement, we do not say, we say a matriculate can apply. Now, if someone comes up to say that no, grace mark was not allowed, grace mark people are not allowed, that is going too much behind the advertisement. The advertisement simply says, you must have a diploma in elementary education. These people have a diploma in elementary education. We have taken in people only who have been certified to be diploma holders in elementary education.
So it says 2-year diploma.
My lord,
It says 2-year diploma, not just a diploma.
Yes, my lord. It's a 2-year diploma. It's specifically mentioned. Page 53.
oh yes. Page 53, the 2-year diploma is something given by the NCT.
My lord,
Now, when the NCT says that this 18-month is equivalent, can they be ignored?
No,
That is what
when
is-
did they say it?
My lord,
When did this notification come out? That
The-
it is equivalent.
the equivalent part, this advertisement is of 2018, that came out in 2000.
What is this?
my lord, it's a new advertisement issued by the
Equivalent-
government, my lord. When if your lordship have a look at para 17, my lord.
Equivalence to Kettiya College?
Here they have specifically mentioned because after filing of this writ petition, they have specifically mentioned it that it is at par with the 18 months
Yes.
DLA.
This was. From the government, the continuing nominee, which would have been in the 8. 31,319. Yes, ma'am. It came on 22/9/2017
And the advertisement is,
of 18.
yes, then
My lord,
this recognition,
my lord, this recognition was done by National Council for Teacher Education, my lord,
Yes, correct.
NCT.
Correct.
Here the what NCT has stated in their affidavit, my lord, is that
Affidavit.
that cannot be for a fresh recruitment, my lord. It was for in-service teachers because why the background, why this has been relaxed, my lord. Already I have given the background, my
in
lord.
service for what? In service teachers, for what purpose? For what? Promotion or appointment
For appointment, my lord.
as?
As fresh teachers, my lord. Through a fresh advertisement, my lord.
Then
That cannot be done. They have, the NCT has already stated in their affidavit, my lord.
but this was issued in 2017,
My lord, yes.
prior to the advertisement.
This recognition was done only to save the jobs of the 14 lakhs unqualified, untrained teachers, my lord, who were holding the post, my lord, in government schools, government aided schools, private unaided schools, my lord.
No, but that is subject to
The
their,
purpose was, my lord,
that is subject to the fact that they should acquire their eligibility under the DLA.
my lord. There is
Moment they acquire the DLA at 18 months,
My lord,
they become eligible.
my lord, it was only not for the fresh recruitment, my lord. That was our claim. And in the advertisement, they have specifically mentioned that the required is 2 years diploma course. Otherwise, they would have said that, mentioned that the diploma in elementary education, 2 years or 18 months DLED course, my lord. They would have definitely mentioned it, my lord.
But this is not a case of causing prejudice to you. How are you prejudiced?
My lord, definitely.
Because
Why I'm prejudiced, my lord?
Hmm.
Because the person who are not having the requisite qualification, they are getting our post, my lord, and we are being deprived, my lord. That is the prejudice, my lord.
no, to make a claim,
My lord.
you must say, firstly, you must identify who are these people who have,
My lord, it is in huge numbers, my lord.
whatever, how many petitioners are there?
My lord, 67, I think, 67.
So 67 petitioners will have to find out.
My lord, it is more than 2,000, my lord. So,
You are entitled to only one post. So 67 petitioners are entitled to 67 posts.
my lord,
This is not a public interest litigation.
my lord.
So on what basis are you staking your claim that someone else who was apparently not qualified or scored lesser marks
My lord,
has been appointed overlooking your claim?
my lord.
You have to make that specific claim.
Yes. my lord.
That claim is not here. Your only claim is that it was 2 years. Now 18 months cannot be
Cannot be
accepted.
considered, my lord.
Then and 18 months 18 months recognition order has come out prior to the advertisement.
Yes.
And if it is a notification of NCTE, then the state is duty bound to follow it.
My lord, but the NCT has itself clarified it, my lord. That is not for fresh recruitment, my lord.
What is the meaning of fresh recruitment? And where is that affidavit? Where is that affidavit?
My lord, affidavit filed by respondent number 3, my lord.
Respondent 3.
On, my lord,
Mr. Goswami is appearing for?
For the MHRD, my lord. For
MHRD.
NCT, Mr. Alam used to appear. Lordship, only two things, the affidavit that he is referring to, what
Hmm.
kind of an affidavit the NCT comes in and how it is contradictory to its own stand. Lordship will kindly have the affidavit,
My
the
lord,
page 3 of the affidavit.
Before
For
that,
a-
may I refer the paragraph, my lord, of the
Mm,
affidavit, my lord.
Yes.
Paragraph 3, my lord,
oh.
affidavit filed by respondent number 3, my lord.
Hmm.
That the answering deponent begs to submit that the NCT recognized the 18 months DLED program only as one-time measure, my lord. And the same is not for regular appointment as teacher in LP and UP schools. As such, selection of the candidates having 18 months DLED degree for fresh appointment in any LP and UP schools are not acceptable and valid one.
So essentially, what you're saying is that those teachers who did not have 2 years DLA will now have an option of having 18 months
Yes,
through open school,
yes,
and they will be retained in their existing posts.
yes, correct.
And for fresh advertisement, this 2 years will apply.
Yes, my lord.
Is his case. Now, my lord, the affidavit he has read out, if Lordship will just turn it over one page.
One page leads to the affidavit.
Lordship will have paragraph 2, that I have read the contents of this application and have fully understood the same. The statement made in paragraphs, totally blank in my, I do not know, my lord, there are true
I
to my
do-
knowledge, and those made in paragraph, I do not know, my lord, which is of record. Now, if Lordship should kindly have my affidavit filed, my lord, at page 42 of my affidavit.
Your affidavit means respondent,
Respondent, my lord, of the director, my lord, filed by the director.
respondent 3,
Respondent, respondent 2.
2, yes,
Lordship will have page 42 for a moment
42 of the affidavit.
of the affidavit, my lord. This is by the NCT. Lordship has, this is by the NCT at the top. To Shri so-and-so Additional Chief Secretary, Education Department, Government of Bihar. Validity of DLED ODL program conducted by NOIS for training of untrained in-service elementary teachers regarding. Please refer your letter number so-and-so on the above mentioned subject, and it is brought to your notice that the NCT has decided to accept the verdict of the Honorable Patna High Court in the case of Sanjay Kumar Yadav versus State of Others, civil judicial number so-and-so. The decision is taken pursuant to the appropriate directions of the Ministry of Human Resource Development. Kindly take further necessary action in this regard.
Hmm.
Now, this Sanjay Kumar Lordship would find, I have attached to the repetition to the affidavit in opposition, page 11.
Yes,
Page 11, my lord, after all the discussions done by the Honorable Patna High Court, I will just, my lord, refer to make it easier. Lordship may have page 24. Para 15.
Hmm.
Thus, I find that on such misrepresentation and misreading of the clarification issued by the NCTE, the Director of Primary Education has illegally issued direction that the persons who obtain DLED course daily run from 18 months by NIS are not eligible for appointment to the post of teachers in primary schools. And thus, the letter contained in so-and-so is illegal, unsustainable, and violative. Writ petitions are allowed. Respondents are directed to allow the petitioners to apply within 1 month. The stand of the NCT Eastern Regional Director is apparent. The NCT headquarters issues a letter saying that we are implementing this judgment. Even then, the regional director of the NCT, as pointed out just herein before, files an affidavit saying no, they are not equivalent. He does not fill up the paragraphs of the affidavit. Such an affidavit, my lord, has been held by this honorable court to be not taken into record for any purposes. Patna High Court has held that it is a misrepresentation and misreading. Page 20, para 14, my lord, specifies also. Then the next judgment, Lordship, I'd like to have at High Court of Tripura at Agartala. Same thing, my lord.
Now
repeated.
this you say is pending before the apex court.
My lord, now, so one matter was decided by the Uttarakhand High Court
That has gone.
in December. And I just find a news quote, my lord, I could not find out the Supreme Court order, but the news quote says that Supreme Court has stayed Uttarakhand High Court order. So I do not know the exact.
What is, where is the Uttarakhand High Court?
Uttarakhand High Court order, my lord, it was in December, perhaps it is not on record. Ships, allow me, I will give the case number. It is,
Where is that notification which was under consideration
the,
in Bihar judgment?
in the Bihar judgment, the Bihar judgment, yes. That I'll point out, my lord. Yes, lordship will have page 17. Para 9.
Page?
17 of the affidavit in opposition, para 9.
No. We want to see the notification.
Of the
NCT,
NCT, that NCT notification.
is it at page 105?
Yes. Page 105, my lord, it does not say that these will not be recognized. This only recognizes the DLED to be equivalent to 2 years. You could find at page 106. And whereas having considered all the facts and figures, the NRC considered the case on so-and-so, decided that recognition be granted to the National Institute of Open Schooling, Noida, for DLED on ODL program through SWAYAM portal of MHRD for training of in-service untrained teachers under section 14 of the NCT and clause 7(6) of the NCT regulations 2014, subject to fulfilling the following conditions. The duration of the said program shall be 18 months instead of 2 years, including the 6 months internship. The requirement of minimum eligibility for admission to DLED program is 50% marks in class 12, to the extent that those who do not fulfill this requirement shall be allowed to take provisional admission to the program, subject to their acquiring 50% before completion. NIS to administer the program through SWAYAM. NIS shall operate study centers manned by staff as per instruction of MHRD to enable NIS to complete training in service untrained teachers numbering around 11 lakh all over India. There shall be no restriction to the number and nature of study centers. Intake capacity at each center shall be maximum 100. Regular inspection monitoring would be done. Then at page 107, this program shall be only for those in-service untrained teachers in government-aided, private, unaided schools appointed on or before 10/8/17. All the provisions of NCT Act regulations other than those relaxed under the clause 12 of NCT 14 would be applicable. Now, therefore, an exercise of power vested under so-and-so of the NCT Act, the Norton hereby grants recognition to NIOS Noida under clause 7(16) NCT recognition norms and procedure programs so-and-so for training in-service trained teachers subject to fulfillment of the conditions mentioned above. Bihar, the Patna High Court and the Agartala High Court, Tripura High Court has totally discussed the effect of this recognition vis-a-vis the liquid
Sorry, come again?
The two high courts, that is the Patna High Court and the Tripura, they have totally discussed the status of the persons who has 18-month DLED to participate in fresh recruitment process. That
By holding it to be equivalent.
they hold it to be equivalent for all purposes, including for fresh appointment. The NCT and the MHRD decided not to go for an SLP before the Honorable Supreme Court and decided to implement the orders and allow the state of Bihar to go ahead, that state of Tripura to go ahead. Now, for the state of Assam, without litigation, we allow such persons to participate. Since the equivalency has been held by one Honorable High Court with regard to a notification which is applicable throughout the territory of India. It is with that respect we go ahead with the selection process.
From the post of lower primary,
My lord.
Is it a feeder category to upper primary also?
My lord, they can the NCT says that NCT uses the word promotion. But for us, it is not a promotion as such. They have to undergo a fresh recruitment process to become a upper primary teacher from a lower primary teacher. However, the past service benefits are given to him. But we do not consider it to be a promotion for the recruitment rules. We consider it to be a fresh appointment.
All right. And this DL, what is that?
DLED, my lord.
DLED
Diploma Elementary
is
Education.
conducted by institutes recognized under NCT.
Yes, it has to be recognized. by the
Syllabus
NCT.
is determined by NCT.
Everything is determined by the NCT. The
The
institute.
DLED is conducted by this open school.
This DLED particular was conducted by the open school, and it was only on this occasion that we had allowed this diploma. In the NCT had allowed an online distance mode process.
Alright.
Otherwise, it has to be school attendance or the attendance of the institute because we needed in-service training. Now, this was this training part, this internship part of 6 months of training, because they are in-service teachers, they are already being trained as teachers. So that part was removed by the NIOS. And the other 18-month
they are not-
curriculum part was there.
I'm differing it, my lord. They are not trained teachers, my lord. That's why here it is written as
No, that-
untrained
That
teachers, my lord.
internship, I used the
No.
one wrong word, that 6 months is an internship period which has been excused by the
But now
NIOS.
they are trained because of DLED.
My
Now
lord.
they are trained
Now
because
they
of
are trained,
DLED.
certified trained.
They are certified to be trained. Your only question is
No,
whether this.
My
were-
learned opponent counsel tries to justify it, the 6 months duration they have rendered in the service of the private institutions or wherever it is, it is considered as considered to be as a trained person,
After they have undergone DLED,
my lord.
The course.
they have obtained the required training or necessary uh, qualification to become a teacher.
But my lord, wherever
Qualified
in the
teacher.
advertisement, they have specifically mentioned it, that it is required qualification is 2 years. They cannot alter it or they cannot modify it unless and
that will-
until there
that
is a
will
corrigendum or
require- that will require you justifying that because of this, your share of posts have been taken over by people who are otherwise unqualified.
my lord.
That factual information is not available.
My lord, as because already I have submitted before your lordships that already huge numbers of candidates were being selected who are not at par with us because unequals cannot be treated as equal, my lord.
Before you jump to that, you have to find out who are the unequals according to you,
My lord,
whether they're unequals.
as already I have submitted,
The
my lord,
interpretation, whether they're unequals or not, will come later. First, you must point out that these are the people
my
under
lord,
such and such
the
district.
admitted fact is that the government's admitted fact is
You
that
did not
they-
apply, you did not apply to the department asking for information,
they have,
assuming.
my lord, I vote on my lord, but the government has admitted that they have recruited the person who are having the 18 months DLS course,
We
my
have
lord.
allowed them to participate. And provisional select list shows the marks secured by the persons who are in the provisional select list. It would have been open for them to say that these are the persons who have secured lesser marks than us.
Okay.
Or at least I come into the foray because this is the last person. to
Are
be
you
selected.
relying on any authorities?
My lord, my two judgments, my lord, I have already given in the along with my affidavit in opposition, the Patna High Court
No, but
judgment
you'll also have to
and the Tripura.
justify that pursuant to the criteria prescribed in the advertisement.
My lord,
Once the selection process has been undertaken,
my lord.
you have decided to alter the one of the.
We have not altered it, my lord. We say
have-
2-year diploma as given by the NCT.
Ah,
It is the NCT norms we have to follow as per the rules. The NCT says that this 18-month is equivalent.
But have you mentioned it in the advertisement? It's
The
not there.
the equivalency part. Is it required to be, my lord?
No, you're,
Because the NCT, once they hold it.
No,
it
no.
already ends, my lord.
no. Kindly come to page 53.
Yes. Page-
This is the criteria. This is the criteria. Very specific, 2-year diploma. It says 2-year diploma. It is not diploma in elementary education by whatever name called. It is a 2-year diploma. This advertisement was issued.
One of the first one says
uh,
senior secondary or its equivalent with at least 50% marks and 2-year diploma in elementary education by whatever name known.
Hmm.
So when the NCT says that this is an equivalent of that,
That is stretching the interpretation little far. Because this is an advertisement.
for the rules, my lord, the rules would justify
Uh,
what would be
Everywhere
required.
it is 2 year, except in the third criteria where it is a 4-year bachelor.
The bachelor in elementary education.
My lord, I'm just referring one judgment of the Honorable Division Bench, my lord.
To what proposition?
Regarding, my lord, non-employment of the parties, my lord. Where there is an arbitrariness or where there is a malice, my lord, the non,
That you have to urge. You have not urged. You have not urged the malice insofar as
the malice is that, my lord,
Ah.
they have, whether they have put the, whereas they have put the criteria as 2 years, but they have admittedly,
that is a matter of interpretation. That
My
doesn't
lord.
require malice. It will be malice only when you say that they have ignored deliberately to give benefit to these people.
my
They are
lord,
otherwise protected.
My lord.
Your argument
yes,
to say that the whole purpose of reducing it to 18 months is to give unfair protection to the people who are in service, who are untrained,
My
etc. But the fact remains, they're in service.
I got your lordship's point.
The moment they complete 18 years, they become protected. They don't have to wait for this advertisement.
My lord.
The only criteria you can say is that this advertisement was meant for fresh recruits.
Yes,
But the advertisement doesn't say so. It says all eligible contractual teachers may apply. The only bar is for regular teachers. You show us that some of the teachers appointed, 50, 60 teachers were regular teachers. So far as the government is concerned,
My lord.
you will have to tell us how you have adopted the selection process, on what basis. This is hardly a selection. What is the meaning of selection?
Finding of the best.
Allotment of marks on the basis of certificates. Is it a process for selection?
The education career of a person as it continues from higher secondary to
We are
the-
talking about lower primary. We are not talking about professors. We're talking about lower primary, where your highest degree is senior secondary.
Yes, but the teachers eligibility test marks as held by the NCT, my lord, whatever is given by the NCT, my humble submission, my lord, that evaluates a person's capacity or the eligibility to be a teacher, and the marks obtained there would therefore carry, my lord, some
All right, you
significance.
address the court on this.
My lord, I agree.
Third learned councils matter posted for further hearing on. Give a date.
Not on the next week, my lord, the week
Let
thereafter.
it be on 14th,
14th, yes. Today is the 12th.
14th. For further
Okay.
hearing.
My lord, 14th, I am,
That is the whole problem.
let it be 14th, my lord, I'll be here.
Let me
No
on 14th.
difficult. I'll be here.
my lord. Make it as pardoned, my lord.
You said further hearing.
Much obliged, my lord.
Obliged.
Yes, learned counsel, so and so and so appears, Mr. Give your names on the sheet,
My lord,
all the council.
obliged.
Highly obliged, my lord.
We want the state to tell us the criteria for selection. And if possible, the position of the petitioners vis-a-vis the selected candidates.
Obliged.
Much obliged.
Yes,
Yes, yes, Your Lordship, I'm praying for adjournment of the matter, Lordship. Today there is some difficulty.
adjourned on the request of MS so and so
After 1 week. Okay, much obliged.
after 1 week.
May I please, your lordship? Yeah, here in this case, my lord, petitioners are the physically disabled candidate and they have appeared for selection in the grade 3 post, my lord. District level committee have selected their candidature, my lord, but subsequently SLC have rejected their, against this, they have approached before this honorable court. And honorable court have set aside and was the SLC's decision, my lord, and directed the authority to appoint them. In the meantime, some of the candidates have been appointed, my lord, but petitioners were left out, my lord. So they have been approached before your lordship for their appointment, my lord. And during pendency of this writ petition, my lord, petitioner number 2, Abed Ali, already appointed, my lord.
Only petitioner number 2.
Petitioner number 2, my lord.
Yes.
And petitioner number 3, 4, and 5 yet to be appointed, my lord.
One,
Your lordship,
1,
1, 3, 4, and 5, my lord.
what is the post they had applied for?
Grade 3 post, my lord.
Grade 3.
And
Where is the advertisement?
advertisement was issued by the social welfare department. my lord.
Where is it? Page number?
Page number 16, my lord.
16.
It is translated advertisement, my lord. Recruitment of physically handicapped person to fill up the backlog vacancies of grade 3 and grade 4 posts lying under various departments of government of Assam. And your lordship found the order is that page, my lord, 18 onwards, my lord. And 11 part is page 41, my lord. There is a detailed order, my lord. Page 41, my lord, para 2, may I read, my lord?
Page?
41, my lord, 41. In the case, my lord. In this case, your lordship.
Hmm.
What transpires is that a recruitment drive was carried out in the year 2005 to fill up of 662 backlog vacancies in grade 3 and grade 4. These vacancies therefore obviously pertain to previous years, that is prior to the 2005-6. Even in this drive, 134 of backlog vacancies could not be filled up. It appears that since in the year 2005-6, no review has been carried out by the state regarding identification of posts earmarked to be filled up by the persons with disability, or to update the list of PPR. In such circumstances, when admittedly petitioners could not be appointed because of anomalies in the selection process, particularly at the time of preparation of state level select list, court is of the view that it would meet ends of justice if a direction is issued to the respondents to appoint the petitioners in the available vacancies related to the recruitment drive carried out in the year 2005 and 6. Naturally, these vacancies are available in different departments, the list of which is available with the social and department or ordered accordingly. Keeping in view of mandate of the Persons with Disabilities Act, all the concerned administrative departments shall cooperate with the social welfare department in ensuring the petitioners are suitably accommodated against the identified post in the respective departments. Social welfare department, being the nodal at a department, shall verify the position of the petitioners vis-a-vis the selection process and proceed with their appointment in terms of their position. And
Yes.
but they are not appointed till 4 petitioners are yet to be appointed. And for this, my lord, we have
No,
also
in this petition,
my lord.
the present petitioners were also petitioners.
Yes, my lord.
Their name, where are their names?
Page 79, my lord, petitioner number 1, my lord.
79. 79.
Sorry, my lord, 29, my lord. Akshendra Patkari, serial number 79, my lord.
Yes.
That is petitioner number 1, is at page 29, my lord.
Hmm.
Akshendra Patkari, my lord. And 2 is already appointed, my lord. 3 is at page 21, my lord. Okonali, petitioner number 3, my lord. Page 21, serial number, my lord. 21 also.
Hmm.
And petitioner number 4, my lord, Beauty Patar, is at page 24, my lord. Serial number 38, page 24, serial number 38, Beauty Patar.
Yes.
And petitioner number 5 is at page 32, my lord. Serial number 95, Syed Ali, page 32, my lord. Petitioner number 5, my lord. And they are the petitioners, my lord, but they are yet to be appointed, my lord.
There was no contempt file.
Quantum file, my lord, and quantum is pending, my lord, along with this petition, my lord.
No, but
And in the quantum petition,
pursuant to the order passed by this court, what orders were passed? What is it that you're challenging in the writ petition?
we are praying for compliance of direction of this order, my lord.
That is a contempt petition. Why are you filing the writ petition again?
Since, my lord, they were not appointed till date, my lord, and
You
there is
filed a
a
contempt.
quantum is there, my lord.
Ah,
And out of that, my lord, they have one of quantum petitioner number 1 already appointed, my lord.
I understand. I'm asking you, why are you filing the writ petition again? You already have an order in your favor.
That is there, my lord.
Ah, so this writ petition is essentially for filing for compliance.
In fact, my lord, for appointment of the petitioner.
That order is already there.
In that case, my lord, I may be allowed to withdraw this petition.
You withdraw
and
it.
Proceed with the quantum petition.
Yes, heard. Learned counsel for the petitioner. This writ petition is filed with the petitioners.
Right.
Who are praying for the direction to the court for appointment of the petitioners against the post in which they were selected by a selection committee within a reasonable period of time. Stop. The petitioners had earlier approached this court by filing WPC number 1424 of 2011 and WPC 399. They were petitioners in which writ petition?
1424, my lord.
1424 of 2011. Stop. The said writ petition was preferred by the present petitioners 1, 3, 4, and 5. Petitioner 2 was also there.
2 was also there.
1, 2, present petitioners seeking a similar direction. Stop. Yeah, the said writ petition was preferred by the present writ petitioners along with other similarly situated persons as petitioners praying for a direction for their appointment in grade 3 and grade 4 posts in the category of persons with disability. Stop. All the petitioners belong to the category of PWD. Stop. This court, by order dated 23/04/2015, disposed of the earlier writ petition being WPC 1424 of 2011, along with WPC 3994 of 2011, with the following directions. Page number 41, last para, and 42. Pursuant thereto, since the order was not complied with, contempt petition being contempt page number 582,
582 of 2007.
2017 has been filed. It is pending. Stop. Present writ petition has been filed by the petitioners seeking compliance of this earlier order dated so and so passed by this court in WPC so and so and so and so. Stop. It is submitted by the learned counsel for the petitioner that in the meantime, petitioner number 2, namely
Abed Ali.
Muhammad Abed Ali, has since been appointed. Stop. However, petitioners 1, 3, 4, and 5 have not yet been appointed. Stop. After submitting for some time, Mr. So-and-so learned counsel for the petitioner submits that since there is already an order passed earlier by this court, by the order dated so-and-so in WPC, order dated 23/4/2015. In WPC 1424 of 2011 and 3994 of 2011. And a contempt petition is also pending. Learned counsel seeks to withdraw. It does not wish to press the presented petition and seeks to withdraw the same. Taking his submissions on record, the writ petition so-and-so stands closed as not pressed. Interim order, if any, stands vacated. Mr. So-and-so appears for the respondents.
C. Sharma, Lordship,
See,
for respondent number 5.
yes,
I appear for respondent number 1 to 4.
names. Yes, in the contempt,
In the contempt, my lord, 582 of 2000 non-compliance of the order, my lord, we have
notices served.
notices served and we have already
Who is appearing for
amended
the
this.
respondents?
the respective officials, my lord, in by filing the mistakes also, my lord.
They are represented. Who is the counsel? Yes. There are 10 respondents.
But none of them appear. For this also, my lord.
একটু নামটো ফ্ল্যাশ করে দিও। এর নাম কেটা থাকে? দুটো নাম। Reply has not been filed.
My lord,
Any reply file?
no, my lord.
Okay. We'll take it up on Friday.
My lord.
Counsels for the respondents are not present,
My lord.
although power has been filed. Matter be listed on Friday. Learned counsel appears for the petitioner.
Obliged.
Yes. Based on 15. Yes, Mr. Dr.
I was supposed to produce the original record.
What is the records about?
Record
reveals that the complaint was served on the petitioner on 13/2/2018. And his statement was also recorded by the internal commissioner.
Lord, my specific statement was not denied, my lord. I made a very specific statement, my affidavit, my lord, writ petition, my lord, the complaint was not served upon me. In fact, it was even not shown to me.
You are who? You are the person accused.
My lord, in fact, my lord, he accuses died, my lord, in the meanwhile, he's expired. His legal heirs have been substituted in the meanwhile.
What is the order passed by the
Removal from service, my lord.
removal from service?
Compulsory retirement, my lord. Compulsory retirement.
Where is that order?
That order, lordship will find, my lord, at page 13, my lord.
Page 13.
He expired during the pendency.
During the pendency. Yes. My case is that, my lord, first of all, no complaint was even served on him. And secondly, my lord, it was on the basis of the internal committee's report, my lord, that he was, my lord, this order of penalty was imposed without being a my lord, regular proceeding, my lord, which is required to be, my lord, undergone, my lord. And my lord, in my paragraph 5, my lord, it made a specific evidence, my lord, that the complaint was not served. And my lord, the reply to that, my lord, in the affidavit is vague, my lord. They have not, my lord, denied, my lord, that contention, my lord.
What is the
Yes,
name of the petitioner?
Pardon, my lord?
Sabir Ahmed.
Sabir Ahmed, my lord. He was called for the, my lord, inquiry, my lord, asked to make his statements, my lord.
Where is it? Where is it shown that it is served?
Lordship notes it.
Note sheet.
Yes. Second note, received letter number so and so, Sabir Ahmed, 13/2/2018.
The order be served on a note sheet, my lord. The complaint has to be forwarded to him, my lord, and note sheet, my lord. I'm not very sure whether this is his signature because this person, my lord, when he signed, my lord, his hands used to tremble, my lord.
You have a look. Show it. Just show it to him.
I've
Is it-
already shown to him.
You have, just give it to him.
Well, just can I see the original? Can I see the original?
You want to see the original? Show him the original. He has ruled.
But this refers to some ICC letter, my lord. This is not the complaint, my lord. I don't know
Hmm.
what this letter contains also. Because it's, my lord, I don't know, my lord, signature, of course, my lord, I cannot stay at this moment, but then receive letter number so and so. My lord, it doesn't talk about, my lord, the complaint. Is it not, it is, whether it's a complaint, my lord, it's not very
What is
clear.
that letter? What is that letter?
That has, my lord, not been annexed to this writ petition, my lord, the affidavit opposition, my lord. The affidavit has been filed, my lord, in page 2. Sorry, page 7, my lord.
Mr. KL, what is that letter?
I'm finding out.
In the affidavit in opposition, my lord, they have not relied upon this letter. Number one, my lord. Number two, there is no specific denial. Number three, my lord, the complaint which has been given, my lord, it is page 7, my lord, of the affidavit in opposition. This doesn't bear any, my lord, my lord, number. So what this ICC letter, my lord, is not understandable, my lord. And suddenly, my lord, this letter, they ought to have referred in their affidavit also, my lord, if this, since I made a specific allegation, my lord, that this copy was not served. My specific argument is paragraph, my lord, 5, my lord. And their denial is very vague, my lord. And secondly, my lord, even otherwise also, my lord, the process of departmental proceeding has to be, my lord, under CCS rules has to be followed. my lord.
Refer to the rules.
My lord, my lord, the sexual harassment of women at workplace prevention and prohibition.
No, you're referring to CCS rules.
No, I first will refer to the
Hmm.
my lord, the rules 2013, my lord, sexual harassment rules, my lord. Subject to the provision of section so and so, at the time of filing complaint, the complainant shall submit to the complaints committee 6 copies of the complaint, along with the supporting documents and names and addresses of the witnesses. So, rule 7, my lord, I'm referring to my
Rule 7.
7, my lord.
Yes.
On receipt of the complaint, second rule 7(2), my lord. On receipt of the complaint, the complaints committee shall send one of the copies received from the aggrieved woman under sub-rule 1 to the respondent in the period of 7 working days. The respondent shall file his reply to the complaints along with a list of documents and names and address of the witness within a period of not exceeding 10 working days from the date of receipt of the documents specified under subsection sub-rule 1. The complaints committee shall make an inquiry into the complaint in accordance with principles of natural justice. The complaints committee shall have the right to terminate the inquiry proceedings or to give an expert decision on the complainant. If the complainant or the respondent fails within sufficient cause to present herself or himself or for 3 consecutive hearings convened by the chairperson or president, as the case may be, provided that such a termination ex parte order may not be passed without giving a notice in writing 15 days in advance to the party concerned. The parties shall not be allowed to bring in any legal practitioner to represent them in the case at any stage of the proceeding before the complaints committee. Conducting the inquiry, the minimum number of 3 members of complaints committee, including the president, officer, or the chairperson, as the case may be, shall be present. Now, my lord, I'll be relying upon a judgment of the Honorable Apex Court, my lord, whereby, my lord, it has been held, my lord, that in such case, my lord, the proceedings under, my lord, CCS rules, my lord, or the service rules, my lord, is a mandatory, my lord. But before that, my lord, Lordship will just have a look at the complaint, my lord. First of all, my lord, this is not a workplace, my lord. That will be my first submission, my lord. Lordship will sign the complaint, my lord, at annexure 2, my lord, page 7 of, my lord, the affidavit in opposition, my lord. But before that, my lord, may I just place the paragraph, my lord, 3 of the reply, my lord, because I had made it,
You sequentialize your
my lord,
submissions.
my lord. Well,
You complete you first tell us what are your pleadings.
Yes.
And what is the case you want to project before this court?
My pleadings are, first of all, my lord, that this is,
Where was the allegation alleged?
yes, my lord, page 7, Lord, of the FN opposition.
No, in the writ petition.
Yes, my lord. In the writ petition, my lord, my lord, I say that, Lord, since it was not furnished to me, my lord, Lordship will come to paragraph 4, my lord, 4 onwards. 3 onwards. That suddenly, by order dated 8/2/2018, issued by the Registrar Assam University, the petitioner was asked to go on leave on 15 days, leave with immediate effect on account of alleged complaint of sexual harassment by a lady student. That by communication dated 12/2/2018, the chairperson of the ICC asked the petitioner to appear before the internal complaints committee of the university on the basis of complaint by one Dipanjali Das for deposition. The copy of the letter dated so and so is annexed 2. That it may pertain to mention that the petitioner was not furnished with a copy of the complaint or any show cause notice, neither with the communication dated 12/2/2018 or before. That on 12/2018, the petitioner, without being shown with the complaint, was told that it has been alleged by the complainant that on 7/2018, evening after the university classes were over, the complainant had boarded a private bus in which the petitioner had also boarded. While both were traveling in the bus, the petitioner had made physical contact with the said lady, and the petitioner was asked to explain what had happened. The petitioner denied that he had done anything, and he was not aware of any such incident taking place. Only thing that the petitioner remembered was that in the seat next to him, a lady student of the university also said, whose identity was also not known to the petitioner. Accordingly, the petitioner was asked to write that he did not know anything about the incident and that he had not done anything, which the petitioner did. Thereafter, one of the members asked the petitioner that since it was a moving bus and since the petitioner and the said student were sitting in the adjacent seat, in some turning, the petitioner might have contacted the shoulder of the complainant. To such query, the petitioner replied that if in any turning, since the bus was moving, the petitioner's shoulder had touched the shoulder of the petitioner, the same was unintentional. The petitioner was then asked to put the same in writing, and one of the members who dictated the petitioner to write that. And if in the turning there was a contact with the shoulder of the complainant, the same was a mistake. Then, my lord, this order of the penalty was, my lord, compulsory retirement was imposed, my lord. And, my lord, in paragraph 13, my lord, I have 12, my lord, alleged violation of principles of natural justice, my lord. 13, my lord, again, I have referred, my lord, the complaint was not furnished to me, my lord. And, my lord, then, my lord, paragraph 15, my lord. 14, my lord, I made a statement that I was pressurized to make the statement, my lord. And paragraph 15, my lord, in terms of the CCS rules, any major penalty, my lord, has to be imposed in terms of the procedure rule, later rule 14, which has also been blatantly violated. Then, my lord, in paragraph 17, my lord, I have referred, my lord, that this is not a workplace, my lord, where the incident allegedly happened, my lord. It is not a workplace as defined under the, my lord, Act, my lord. So therefore, my lord, my case is, my lord, that the imposition of penalty was, my lord, done without, my lord, following the due process and totally without jurisdiction. That is my case, my lord, in my affidavit, my lord, writ petition, my lord. Now, my lord, in para 3, my lord, with regard to my contentions, my lord,
Para 3
of their affidavit. With regard to my contentions, my lord, that I did not receive the copy of the complaint. Well, lord, they have replied. With regard to the statements made in paragraph 3, 4, and 5 of the writ petition, the answering respondent stated the petitioner was directed to go on leave due to the alleged complaint of sexual harassment by a lady student against him, and the leave shall be adjusted against the kind of leave due to his credit. Further, it is submitted that the complainant submitted the said student to the honor complaint submitted the said student to the honor of the vice chancellor, against the petitioner was referred to the internal committee, complaints committee for inquiry as per rules and guidelines holding the field in this regard. So that specific statement that it was not served upon me, my lord, has not been denied, my lord. And my lord, in reference to that, my lord, they have annexed, my lord, this copy of the complaint, my lord. And my lord, letters, my lord, complaint, my lord, and.
But you appeared before the committee.
I appeared with the-
You appeared before the committee. So how did you come to appear before the committee?
I was asked to appear, my lord, by this letter, my lord.
So during that time, do you still say that the complaint was never available to you?
And not at all, my lord. Even I was not shown the complaint. That's the statement I made, my lord.
Where? Paragraph?
Paragraph, my lord, 6, my lord. That on 12/2018, the petitioner, without being shown with the complaint, was told that it has been alleged. He was only, my lord, told that this is the allegation against you. That's what I've specifically said, my lord.
Hmm.
Now, so-called letter, my lord, which my learned friend,
Para 6,
para 6, my lord.
subpara 6, subpara or para 6. You stated, you
Ah.
submitted that
It is in this context, it is pertinent to mention that the petitioner, though requested a copy of the complaint be furnished to him, the members of the ICC refused to provide with the same and told the same contained what was narrated to him. Thereafter, the said member pressurized the petitioner to make a statement. One of the members, so-and-so, was even directed for the petitioner to write.
Ah.
Now, my lord, therefore, my lord, this specific case was, my lord, that the
right what?
my lord, the statement, my lord,
What is the statement?
that, my lord, that I had referred in paragraph 6 earlier, my lord, that thereafter one of the members asked the petitioner that since it was a moving bus and since the petitioner and the state student were sitting in the adjacent seat, in some turning, the petitioner might have contacted the shoulder of the complainant. To such query, the petitioner replied that if any turning since the bus was moving, the petitioner's shoulder had touched the shoulder of this petitioner, it ought to be complained. The same was unintentional. The petitioner was then asked to put the same in writing, and one of the members dictated to the petitioner to write that if in the turning there was a contact with the shoulder of the complainant, the same was a mistake. Now, Lordship will find, my lord, that complaint, my lord, at annexure, my lord, 2 of the writ petition, my lord. Sorry, my lord, affidavit in opposition. My lord. Annexure 1 is the letter by which he was asked to go on leave, my lord. 8/2018. Then, my lord, this is the complaint, my lord. Annexure 2.
Hmm.
With all due respect, I hereby state that one of the office staff of the Department of Linguistics, whose name we later discovered to be Mr. Shabir Ahmed, misbehaved, within bracket, touching my private parts, with me on a public transport on a way back home on 7 February 2018. I thereby request you to take proper actions so as to ensure my safety and security. Now, the workplace has been defined under the Act, my lord.
Hmm.
Lord, 2O.
Yes.
2O, my lord, the places that define 2OV, my lord,
2O,
V. 5, sorry, 5. 205, 5, yes. Any place visited by the employee
Hmm.
arising out of or during the course of employment, including transportation provided by the employer for undertaking a journey. So this was not a transportation provided by the employer, the private, my lord,
transportation provided is included.
including.
Including.
Yes, my lord. Any places visited by the employee arising out of during the course of
Employment,
So, my lord, visiting-
including,
Yes, including transportation provided by the employer. So, my lord, the transportation has to be provided by the employer,
no. Including transport.
my lord. So, out of the course of,
It can be interpreted
My lord.
that any place visited by the employee
my lord,
during the course of employment,
my lord.
including transportation.
My lord,
provided,
Yes, ma'am.
so
Visited
visited any place,
during the course of employment,
employment.
course of employment. So he has to visit any place during the course of employment. Madam.
What is the, now who's an aggrieved woman?
She's a student, madam. She's not employed.
What is the definition of an aggrieved woman?
Aggrieved woman, madam, she can be an, well, that, madam, I'm not, madam. Aggrieved woman definition, madam, QA, madam. In relation to workplace, a woman of any age, whether employed or not.
Exactly.
So madam, that, student, madam, that I'm not saying, madam, that she's not a, madam, aggrieved woman.
So
That-
in that context, you'll have to interpret workplace.
Madam, workplace, madam. therefore,
Any place she's visiting,
Madam.
arising out of or during course of the employment,
Madam.
which includes transportation.
Madam, no, madam. Going to the, madam, going to the department, madam.
Doesn't restrict by way of transportation
Madam, going to the, while going to the department, madam.
and coming out.
While going to the department, madam, in a, madam, transport provided by the.
No, going to the department and
Madam.
coming out.
Madam,
It is silent
Madam,
whether transportation is included or not, but
Madam.
it is included. We will include a transportation provided by the employer.
Madam.
Could be one of the interpretation. Otherwise, this any place visited
by the employee.
By the
arising
employer.
Out of during the, course of employment. Including transportation provided by the employer for undertaking such journey. So, madam, this journey, madam, if it is, madam.
No, you cannot emphasize only on the journey part. The emphasis on any place visited by the employee,
Madam. So any place. visited by
arising
the
out of or during the course.
Course, madam.
So that place
Yes, madam.
can be a particular, it can be a movable place.
What your lordship is trying to say is that since it's including transportation, therefore, my lord,
No, what I'm saying is it has to be there is no dispute that she's an aggrieved woman,
yes, ma'am, there's no dispute.
assuming the allegations
Yes,
are correct.
yes,
Now the question is whether it is a workplace or not.
madam,
If she is not employed,
madam,
if she is not employed,
Ma'am.
which she is, therefore it can be clause number 1, department, organization, so and so attributable to be. Now the incident took place in a transportation, in the process
Ma'am.
of going back home. So it has to be any place visited by the employee arising out of during the course of employment, including transportation.
Right.
It doesn't, the emphasis is not on the transportation, according to me.
what your lordship is. trying to say
Emphasis,
is-
emphasis is on any place,
Movement of within the, within the course.
in and out. Otherwise,
Right.
if you exclude the transportation part,
Right.
unless provided by the employer,
Right.
then it will carry no meaning to workplace so far as a woman under aggrieved woman
Madam,
under clause A1 is concerned.
madam, I can see what is falling from your lordship. But then, madam, I would, well, focus on the other points.
It has to be given some purposive meaning.
My lord. I'll focus on the other points, madam, with regard to madam,
Yes.
that,
Yes.
the complaint, madam, the manner in which the complaint was made. Madam. So, madam, my first submission is that, madam, that's, this, communication was, madam, not at all, madam, served on it. It's complaint, rather. What my learned friend has produced, madam, is some letter of the which says ICC letter number 20, madam. It
But you
doesn't,
did not make the person a party. The member who dictated
dictate, madam. That
is not arrayed as a party.
Not made it, madam. Even otherwise, madam. Even otherwise, madam. There are other members, madam. I'm making an allegation, madam, that this complaint was not served upon me. The record shows some ICC letter was given to me, madam.
All right,
even assuming,
complaint-
madam,
all
that-
right, let us take it that the complaint was not served, but
Not served, madam.
there was some inquiry undertaken.
Yes, madam. I was asked to make a statement. before the company, madam. I
Your
made a
statement was
madam.
there.
Now, my lord, therefore, my lord,
Where is the statement? Where is that
As
statement?
plate mark.
Huh?
The record has plate mark,
Not here.
not here. On right side, lordship, have written the name of the state, deposition of Sabira Mehta.
And my lord, on the basis of this, my lord, inquiry committee report, my lord, I was, this order of penalty, my lord, of compulsory retirement was issued.
Yes. Hmm. So where are the depositions?
It is available in the original report. It is,
Here?
yes,
No, only his depositions are there.
no, lots of other depositions also there.
What is the name of the complainant?
Complainant.
Gitanjali Das, I think.
Yes.
But I'll be relying upon the judgment of the honorable apex court, my lord.
No, but then after that, you were saying that the rules of CCS have not also not been followed,
Yes, ma'am.
that you have not.
That on
reduced-
that I'm relying judgment.
On?
My lord, that aspect, my lord.
But take us through the rules first.
My lord, before that, then lordship will, my lord, kindly look at the lord page, then lordship will go into the rules, my lord. The act, my lord, 2013 Sexual Harassment Act, that provides, my lord.
Yes.
My lord. Page 11, my lord, sorry, my lord, section 11, my lord. Section 10, my lord, contains provisions for, my lord, conciliation, my lord. Thereafter, my lord, the inquiry into the complaint. Subject to the provision of section 10, the internal committee or the local committee, as the case may be, shall, where the respondent is an employee, proceed to make an inquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent, and where no such rules exist, in the same manner as we prescribe, or in case of a domestic domestic worker, the local committee shall, if prima facie case exists, forward the complaint to the police within a period of so and so days. So, my lord, this is what, my lord, as per the service rules, we have to proceed, ma'am. This is what it prescribes, ma'am. And, my lord, for this university employees, my lord, the CCS rules will not apply, my lord.
CCS rules would not apply.
Apply, my lord. Apply.
Apply.
Then, my lord, Roshi will kindly turn to below, section 13.
And you read out the subsections of section 11, starting from subsection
2, my
1.
lord. Notwithstanding anything contained,
No, start from subsection 1.
1, my lord. Subject to the provisions of section 10, the internal committee or the local committee, as the case may be, shall, where the respondent is an employee, proceed to make inquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent, and where no such rules exist, in such manner as we prescribe, or in case of a domestic worker, the local committee shall, if a prima facie case exists, forward the complaint to the police within a period of 7 days for registering the case under section 509 of the Indian Penal Code and any other relevant provisions of the state code wherever applicable, where applicable, provided that where the aggrieved woman informs the internal committee or the local committee, as the case may be, that any term or condition of the settlement arrived at under subsection 2 of section 10 has not been complied with by the respondent, the internal committee or the local committee shall proceed to make an inquiry into the complaint, or as the case may be, forward the complaint to the police. Provided further that where both the parties are employees, the parties shall, during the course of the inquiry, be given an opportunity of being heard, and a copy of the findings shall be made available to both the parties, enabling them to make representation against the findings of the committee. Notwithstanding anything contained in section 509 of the Indian Penal Code, the court may, where the respondent is convicted of the offense, order payment of such sums as we may consider appropriate to the aggrieved woman by the respondent, having regard to the provisions of section 15. For the purpose of making an inquiry under subsection 1, the internal committee or the local committee, as the case may be, shall have the same powers as are vested in the civil court under the Civil Procedure Code 1908, while trying a suit in respect of the following matters, namely, summoning or enforcing the attendance of a person or examining him an oath, requiring the discovery or production of documents and any other matter which we prescribe. The inquiry under subsection 1 shall be completed within a period of 90 days. Then, my lord, section 12, my lord. Inquiry into complaint. During the pendency of an inquiry on a written request made to the aggrieved woman, the internal committee or the local committee, as the case may be, recommend to the employer to transfer the aggrieved woman or the respondent to any other workplace, grant leave to the aggrieved woman or for a period of 3 months, or grant such other relief to the aggrieved woman as been prescribed. The leave granted to the aggrieved woman under this section shall be in addition to the leave which she would be entitled, otherwise entitled. On the recommendation of the internal committee, the local committee, as the case may be under subsection 1, the employer shall implement the recommendations made in the subsection 1 and send the report of such implementation to the internal committee, the local committee, as the case may be. Inquiry report. On completion of the inquiry under this act, the internal committee, the local committee, as the case may be, shall provide a report of its finding to the employer. Or the case may be to the district officer within a period of 10 days from the date of completion of the inquiry, and such report be made available to the concerned parties. If the internal committee or the local committee, as the case may be, arrives at a conclusion that the allegations against the respondent has not been proved, it shall recommend to the employer and on the district officer that no action is required to be taken in the matter. Where the internal committee or the local committee, as the case may be, arrives at a conclusion that the allegations against the respondent has been proved, it shall recommend the employer or district officer, the case may be, to take action for sexual harassment or misconduct in accordance with the provisions of the service rules applicable to the respondent, and where no such service rules have been made in such manner as may be prescribed. To deduct, notwithstanding anything contained in the service rules applicable to the respondent from the salary or wages of the respondent, with some as may be considered appropriate to be paid to the agreed woman or to the legal heirs, and it may determine in accordance with the provisions of section 15. Provided that in case the employer is unable to make the deductions from the salary of so-and-so, salary of the respondent due to his being absent from the duty of cessation of employment, it may direct the respondent pay such sum agreed to the woman. Provided further that in case the respondent fails to pay the sum referred to in the clause 2, the internal committee, as the case may be, the local committee, may forward order for recovery of the sum as an area of land revenue of the concerned district officer. 4. The employer district official will act upon the recommendation within a period of 60 days of receipt by him. So, if there is a finding against that there is a offense, conclusion there is an allegation has been proved, then it's to be recommended to the employer for taking action against as per the service rule. So, a regular processing has to be followed by after the inquiry committee reports comes in. And here, my lord, in this particular case, my lord, on the basis of the report, my lord, the order of my lord compulsory retirement was issued without further my lord proceeding as per the service rules.
There is an appellate forum, appellate provision for an appeal.
Well, that's when the procedure has not been followed, my lord. There ought to have been a regular procedure, my lord.
This could have been urged before the appellate authority.
That he did not at that point of my lord time, my lord, and the manner in which it was conducted, my lord, they will, my lord, the executive, my lord, in fact, the executive council took the decision, my lord. So therefore, this appeal, my lord, would have been, my lord, meant no purpose, my lord. The highest authority, my lord, took the decision to, my lord, compulsory retirement, my lord.
On the basis of the
Report,
findings.
my lord. That
So
finding, my lord,
your findings or recommendations
yes, but recommendations, my lord.
are appealable.
Well, because the executive council will took a decision, my lord. It is the highest
The
authority.
appeal is against the recommendation.
True, my lord. But then since the executive, my lord, this on the basis of this order, my lord, even this without this order of recommendation of the council, my lord, he was sent on compulsory retirement by the executive council, my lord. So therefore, thereafter, my lord, he had got nowhere else to go, my lord. The executive council, my lord, having taken the decision, my lord, that he should be compulsory retired, my lord.
Where is that order?
Page 13, my lord, annexure 3 of my writ petition.
Page 13,
13, my lord. Annexure 2.
1-3.
It's a 4, my lord. 3, my lord. Annexure 3, page 13. 6/4/18, 2018.
Yes.
In pursuance of the resolution number so and so, in a meeting special of the Executive Council of Assam University, Silchar. So and so, Department of Linguistics is hereby sent to compulsory retirement with effect from so and so. By imposition of major penalties provided in Rule 11(4) of the CCS rules, 1965. According the incumbent will be paid admissible benefits under the provisions of CCS pension rules 40 within bracket 172.
Okay, and what is the judgment that you're relying on?
Judgment relying, my lord, is Dr. Vijay Kumaran CPV versus my lord, Central University of Kerala, Kerala, my lord.
Hmm.
Here also, my lord, on the basis of the inquiry, internal committee report, my lord, this person, my lord, was penalty was imposed, my lord.
Hmm.
And the Honorable Apex Court has, my lord, stated, my lord, that the complaint of the brought to its logical conclusion, my lord, by holding a not only initiating, my lord, departmental inquiry, regular inquiry, as per service source, my lord, but also followed by other actions. My lord. Paragraph 12, my lord, is my lord, operative part, my lord. And my lord, if your lordship looks at, my lord, that in this case also, my lord, the internal committee was my lord, constituted. The internal committee constituted, my lord, reported, my lord, against him, my lord. And on the basis of that, my lord, the vice chancellor, my lord, issued the termination order. Honorable Apex Court has held, my lord, that paragraph 12, my lord, upon receive the complaint from the agreed woman about the sexual harassment in the workplace.
Because of the major penalty,
My lord.
he's sent to compulsory retirement.
My lord.
So no pension. Yes.
Activities one.
Is
And on
it
the basis-
sufficient to discharge,
Okay.
terminate him or send him on compulsory retirement?
Yes, he was sent on compulsory retirement.
No. Is an inquiry under ICC sufficient to send him?
Lordship, in this directly, I want to place on judgment of this honorable court. Paragraph.
But there was no inquiry held.
Yes,
separately.
beside there was no separate. That is admitted. Paragraph 36. In case of Medha Kotwal Lele Supra, the Honorable Supreme Court held that the report of the complaint committee on sexual harassment can be treated as finding of guilt of that delinquent for purpose of imposing penalty. It is therefore evident that it was permissible for the appellant university to take appropriate action against the respondent treating report of the CCHS dated so as per the inquiry report and subsequent inquiry proceedings by appointing DN Soik as inquiry officer. However, we find that the inquiry officer had conducted the proceeding in a fair manner, giving full opportunity to the respondent and finding reflected in the report dated so and so are also recorded on the basis of cogent evidence on record. Therefore, viewed from any angle, the impugn order of penalty dated so and so was not suffer from any infirmity. Two thousand sixteen 3 GLP 569.
2016 GLP 569.
Permissible under what? Under some rules.
That's it. This matter was also relating to university. It was a case for university.
When was the incident complained of?
What's it?
When was this incident complained of?
In the present case,
Yes.
2018.
2018.
2018, February laws.
Please take us to the proviso, newly inserted proviso under Rule 14(2) of CCS.
CCS. Rule 14, I think.
14(2).
Yes, sir. Provision is made.
Conduct Rule 2. Conduct.
Provided. Provided
Yes,
it
yes.
said there is a complaint of sexual harassment within the meaning of Rule 3C of the Central Service Conduct Rule 64. The complaints committee established in each of the ministry or department or office for inquiry into such complaint shall be deemed to be inquiry authority appointed by the discipline authority for the purpose of these rules, and the complaints committee shall hold if separate procedure has not been prescribed for the complaint committee for holding the inquiry into complaint of sexual harassment. The inquiry is practicable in accordance with the procedure laid down in this rules. Was inserted in 2004 law.
What does your statute and all say?
Lordship, university has no separate rule with regard to.
Nothing.
No.
No
following-
statute, ordinance, regulation.
Ordinance is there,
Ah.
but they doesn't speak about this situation. Although as per the Supreme Court judgment direction, internal committee is there.
Hmm. Yes, Mr. Dotto.
Madam.
Pursuant to the insertion of the proviso under Rule 14(2),
Pilot.
no separate inquiry is necessary.
Well, this judgment is of 2020, my lord, where this honorable court has, my lord.
I don't know if it is,
Yes,
if it is referred.
2020, my lord.
Hmm.
This is 2020, my lord. And my lord, here, my lord, here's
No,
here's
but
also, my lord. case
Here,
study.
is this a proposition for CCA rules?
Yeah, in the university, my lord, because the punishment has been imposed on the CCA rules, my lord. It's not in dispute that, my lord, CCA rules is not applicable to the university staff, my lord.
Hmm?
It is not in dispute whether the CCA rules is not applicable to the university staff, my lord. And the punishment has been imposed on the CCA rules, my lord. That the impugner itself reflects.
No, the judgment, we're
Pilot.
referring to the judgment that you have referred.
Yes, my lord. Yes, my lord. Here, my lord, on the basis of the inquiry committee, my lord,
No,
ICC
under what rules? Under what provisions? This is under UGC.
well, there is a UGC regulation of 2015 also, my lord, that has also been referred here, my lord,
Right,
which amplifies, my lord, that the procedure has to be followed, my lord.
but
As-
is
as
it
per,
an
my lord, a
authority
regular
for,
proceeding, my lord, a regular proceeding, my lord, as per-
was the punishment imposed under CCS rules?
in this case, my lord,
Apparently not.
my lord, she was, my lord, vice chancellor, my lord, issued this, my lord, on the basis of inquiry committee report, my lord.
No, no,
No, separate rule is not here.
This judgment has not been carried further, Mr. KL.
Lordship, I didn't find lordship.
Have you gone through this judgment?
This has been well, learned, my lord. I've just tried to got it, my lord, but then I've not gone through it, my lord. But here, my lord, there was some kind of an inquiry, my lord, which the honorable court found, my lord, was properly done, my lord.
No, no. In your case,
My lord.
although you allege that there was no inquiry done,
Yes, my lord.
yes, according to the university, there was some inquiry done.
Yes, my lord.
But you secondly move the argument that the CCS rules have not been followed, but you have been sent on compulsory retirement.
My lord.
That perhaps after incorporation of the proviso
My lord.
and read with the judgment,
My lord.
doesn't require a call for any such separate proceedings.
No, but here, my lord, in this.
So the only
Yes, my lord.
question is whether the inquiry of the ICC
My lord.
was duly conducted as per
My-
rules.
Yes,
My lord, my humble submission to you, my lord, as per this judgment of 2020, my lord, it is also with regard to an university, where, my lord, this aspect has been taken into consideration, my lord. And, my lord, it has been held, my lord, that lordship will see, my lord, the operative portion, my lord.
No, no,
of the
merely
judgment, my lord.
because you see, either you say that the further proceedings under UGC is necessary to have been conducted by the university.
My lord.
They have followed CCS rules.
My submission is twofold, my lord. First of all, my lord, the internal inquiry committee, my lord, complaints committee, did not follow the my lord, prescribed procedure. my lord.
That we will.
There is a
look
lapse
into.
on their part. Number two, my lord.
Hmm.
So far as, my lord, the allegation is concerned, my lord, this my lord, allegation ought to have been taken into logical conclusion, my lord, by following a disciplinary proper
That
process.
is what we are asking you in the
Exactly,
face
ma'am.
of this division bench judgment.
Yes, my lord.
You address us on this.
My lord, that's why I'm relying on paragraph 12 of this judgment of Supreme Court, my lord, 2020, my lord, which I was relying upon. my lord.
Hmm.
That is Dr. Vijay Kumar and CPV.
Yes,
My lord, paragraph 12, my lord.
yes.
Upon receipt of the complaints from the agreed woman, girl student of the university, about the sexual harassment at workplace, in this case, university, it was obligatory on the administration to refer such complaints to the internal committee or the local committee within the stipulated time period as predicted in section 9 of the Sexual Harassment Women's at Workplace Prevention, Prohibition and Redressal Act 2013. Upon receipt of the complaint, an inquiry is required to be undertaken by the internal committee or the local committee in conformity with the stipulations of section 11 of the 2013 Act.
65 to CCS.
The procedure for conducting such inquiry has been amplified in 2015 regulation. Thus understood, it necessarily follows.
So it has reference to the regulations.
Regulation is of the UGC, my lord. It is reference to the.
Mr. Dr. The query of the court
My lord.
is it your case that without reference to the regulations, the entire proceeding goes?
My lord, here the.
Is it
regulation-
your case that placing reliance or reference to the CCS
My
rules
lord.
in the face of these regulations is not proper?
My lord, the regulation referred to, my lord, here is the UGC. my lord,
UGC regulations,
Yes.
correct?
with regard to sexual harassment, my lord.
Correct.
So that has also been amplified, my lord. What this says, my lord, is been amplified by.
You are
this regulation.
skirting the question, Mr. Doctor.
My lord.
Question is very specific.
My lord.
This judgment is an authority that if you are conducting the inquiry under UGC rules,
My lord.
regulation, whatever directions the court has given
My lord.
is required to be followed.
My lord.
But is it an authority to say that even if you conduct it under CCS rules,
My lord.
that procedure has to be followed, notwithstanding
My lord.
the insertion of the proviso?
Probably. I'll go a little forward further, my lord.
Yes.
The procedure conducted for such inquiry has been amplified. So and so. Thus understood, it necessarily follows that an inquiry is a formal inquiry required to be undertaken in terms of 2015 regulation. The allegations to be inquired into by such committee of being sexual harassment defined in section 2 and read with section 3 of the Act, being a serious matter bordering on criminality, it would certainly not be advisable to confer the benefit on such employee by merely passing an order of termination. Such complaints ought to be taken to its logical end by not only initiating departmental or regular inquiry as per the service rules, but also followed by any other actions as per law.
Exactly. Service rule don't say it doesn't require the CCS rules. As per service
lord.
rules,
My
they
lord.
don't have service rules.
My lord,
They're following CCS rules.
my lord,
CCS rules, the insertion of the proviso
my lord.
says it's not required.
Well, just I'll finish it off, and then I'll make my submission. In such a case, a regular inquiry or departmental inquiry as per service rules is required, a service rule is also indispensable so as to enable the employee concerned to vindicate his position to establish innocence. We say no more. Well, here,
Yes.
Lordship, Lordship, can spend some time, I'll address on this tomorrow.
That's all. We are closing the hearing.
Just
The
down this.
hearing for the whole day, you are
Hello.
asking for time.
But just on this point, my lord, that my lord, because regulation 2015, my lord, just started placing that.
We have heard you for the greater part of the day.
So
Sorry.
my humble submission will, my lord, even my lord, so first, this proceeding is concerned, first of all, my lord, as I've said, my lord, that this part is vitiated on the ground, my lord, that no inquiry report was, my lord, that complaint was given to me, my lord. Secondly, my lord,
Have you gone through the judgment of the division bench?
no, my lord.
All right. Thursday.
Right.
You go through,
My
address us. You address this court with reference to the judgment you have relied on
Right.
to say that notwithstanding placing reliance on this proviso,
my lord.
you still have to conduct a
Department letter.
departmental proceeding. Thursday, hardened part. For further hearing. হ'ব ইয়াত লগত বান্ধি দিব Thursday আছে কাইলৈ পঠিয়াই দিব ৰাখি দিম। Mr. KL, you can take back the records for the time being. You can give it to us on Thursday.
Item number 7, I am for the respondent, my lord. The affidavit is required to file. My prayer for lordships, 2 weeks further time is required to file the affidavit.
Who's for the petitioner?
But, as Bora, he was in the morning, I met her.
Hmm.
She must start up in another court.
Mr. UK Goswami, learned counsel for the respondents. Praise for further time for filing reply affidavit. List after 2 weeks.
Earlier.
Ma'am, please, Lordship. Petitioner before your Lordship is a widow of an
officer, my lord, who was a branch manager of Assam Gramin Vikas Bank. While he was working, my lord, as a branch manager in Gramin Vikas Bank at Gorukuti, there was a suspension, my lord. He was placed under suspension and he has all communicated, my lord. Thereafter, departmental proceeding was initiated. Then, my lord, we have replied. Thereafter, my lord, internal inquiry was conducted. I asked for certain documents, but that has not been given me, my lord. That your lordship will come to directly, my lord, page 98 onwards, my lord.
Let us see the allegations first.
Allegation, before lordship, go to the page 36 is the suspension, my lord.
You are challenging the suspension.
No, my lord.
Then
I am challenging, my lord, departmental dismissal order as well as, my lord, the consequential benefits I need, my lord, because during pendency of
you are
the,
also challenging the inquiry.
no, my lord, I'm challenging, my lord, entire proceeding.
So where are the allegations, statement of allegations?
Allegations, lordship, first we'll see the suspension, why I was placed under suspension, my lord.
Yes.
Page 36. May I read, my lord?
Yes, yes.
Whereas the disciplinary proceeding is contemplated against Mukut Chandra Sharma, Assistant Manager of Gramin Vikas Bank Nalbari branch, of certain gross misconduct and alleged to have been committed by him at bank's Gorukuti branch during the tenure, and considering the seriousness and gravity of the alleged misconduct, undersigned hereby place Mukut Kumar Sharma, Assistant Manager, Gramin Vikas Bank, placed under suspension with immediate effect, pending departmental inquiry and its final decision. During suspension period, my lord, what I'll get, my lord. Thereafter, lordship kindly turn to page 37. 37 was issued to me asking for shock cause, my. It is alleged that page 37, lordship. It is alleged that during tenure service of the branch manager bank at Gorukuti branch from 25/16 to 7/5/19, you have sanctioned and disbursed allotted 217 now 100 numbers of self-help group SSG loans with a period of 16 months from so and so to so and so, altogether an amount of 4,15,20,000, my lord, that is 4,15,20,000 sanction against 217 number of self-help groups sanctioning these loans, and you had committed gross serious and misconduct, which was to the narrated below, my lord. They have given some list, my lord. Thereafter, my lord, lordship will see page 32, why what has been asked upon me, my lord.
32.
41, my lord, last paragraph. Focus serial number 9.
Yes.
Lordship has come across. Transaction and recovery status of the accounts are very poor and highlighted. There is an outstanding amount of 4,19,52,000 SSG loan account against your sanction amount of 4,15 lakh. As the loans is going to early month category, these facts reveal that the reckless by you had exercised your discretionary power, causing huge financial loss to the bank. Then lordship come to page 42. In view of the above, you are hereby advised to explain the conduct of the aforesaid seriousness irregularities committed during the tenure of the service of the branch manager of Gorukuti branch. Please show the cause why disciplinary proceeding will not be initiated against you for the commitment of these irregularities. Your reply should reach undersigned within the 15 days. Thereafter, my lord, page 43, annexure 3, my lord, I have replied all the contentions, my lord. There is some allegation was there, my lord, because in the bank, my lord, there was no checkbook was readily available. Accordingly, my lord, withdrawal slip was issued, used in place of the check, my lord. Then I have replied, my lord. After reply, I have denied all the allegations. Thereafter, my lord, I have been issued another letter at page 51. Page 51.
Hmm.
We have received your letter dated so and so. In response to your reference in this connection, we have to inform you the reply furnished by you is not found by the bank to be satisfactory and convincing. It was issued by general manager. Thereafter, my lord, page 52. Page 52, my lord. It was issued to me, my lord, in response to the so-and-so Vikas Bank employed so-and-so rules, so-and-so intuition of the misconduct which has been, as the inquiry is proposed to be held below mentioned. Then list of all the same thing, my lord, repetition that I have given, my lord. Then inquiry was conducted. After not being satisfied, my lord, then, my lord, page 60. Page 60, my lord, inquiry was proposed to be held, my lord. Last line, my lord, having done so, you have grossly violated the section 18 and 20. Lordship, kindly remember these two sections, my lord, regulation 20 and 18 and 20. Grameen Vikas Bank, so and so, that which I'll supply, my lord. Thereafter, my lord, I have given, my lord, article of charges was given to me, my lord. Again, I have denied all these things during inquiry, my lord.
Hmm.
During inquiry, my lord, I have given my all the reply. My lord. Thereafter, my lord, at page 70, an inquiry
Inquiry
officer
officer.
was
Hmm.
appointed, my lord.
Yes.
Lordship has come across, my lord. The third paragraph, my lord, whereas the undersigned considers the appointment of inquiry officer to inquire into the charges level in the charge sheet mentioned herein above to appoint the presiding officer to the present bank case as inquiry in the exercise the power conferred on the regulation 41 read with 30 regulation 31 Assam Grameen Vikas Bank officers employed so and so, my lord. So appointing, my lord, Tejinder Nath Gogoi was appointed as a inquiry officer. Thereafter, my lord, inquiry was going on, my lord. Thereafter, my lord, inquiry has submitted, my lord, his report, my lord, and is conducted his report. Page 84 is the operative part, my lord. During inquiry, the CSO was not able to defend himself against any of the charges level against him, nor was able to produce any documentary evidence in his support. Thus, all the charges level against so-and-so has been established. During inquiry period, my lord, thereafter inquiry, I have submitted my written argument at page 85. I have denied all these things, my lord. Thereafter, my lord, what happened during inquiry? Before that, my lord, at page 99, my lord, type copy, lordship will see, I asked for several documents during inquiry, my lord. Is a type copy, my lord. 99, my lord, before that page, there is annexure 11, my lord. That is somehow important, my lord.
Hmm.
Order dated so and so passed by the departmental inquiry proceeding against Mukesh Sharma so and so. Prior for supply of the copies of the document bearing serial number 4, 5, 6, 7 and any statement, if any. Statement any, my lord.
Hmm.
With due respect, I beg to state you that the charge sheet of officer, the departmental inquiry proceeding charge number so and so on 28/2 when I was present in the aforesaid departmental inquiry and honorable inquiry officer in the above mentioned departmental inquiry officer was pleased to pass following order. The defense is allowed to 15 days from the date to verify the documents listed ME3 in original. PO is directed to arrange the verification of the original document with the listed document within the specified period of the receipt and so defense side to submit the same to the inquiry officer. Defense side also given 15 days to discover the defense document witness if any required for the purpose of then lordship turn to page 100, madam. But that, sir, you were pleased to fix the departmental inquiry on a hearing on 18/3/20. That's, sir, most respectfully back to state that I have already received the list of
So
documents.
finally, your inquiry was held.
Inquiry was held given after against me, madam.
Yes.
But during inquiry, I asked certain documents
Hmm.
that was not supplied, my lord. That's why, my lord, On the last occasion,
What
honorable,
documents you are?
documents, my lord, that your lordship will see page 99. Some exhibit, my lord, they have relied inquiry officer, my lord. 4, 5, 6, 7, and ME3.
Hmm.
Statement of so and so.
Hmm.
I have repeatedly written, my lord, page 100, it is the thing will be clear, my list of document witness for
How
the
did you-
copies of
how-
the documents, more particularly serial
Is-
number 4, 5, 6.
Is it disputed, Mr. Doctor?
Record will reveal, my lord.
That-
Lord, so far document and all these, my lord. If your lordship look at the record of the disciplinary proceeding, he verified all the documents. He accepted, my lord, saying that defense has accepted and verified all the documents. Now, when the inquiry proceeding were saying all that, my lord, now saying that the relevant documents were not furnished to us, is it believable?
No, no,
And-
was this letter, was this
Letter must be
communication addressed and did you respond to this?
My lord, on 18/3/2000, my lord, that I'll take your lordship to that. On 18/3/2020, the disciplinary proceeding shows that, my lord, he verified the document. He did not raise at that relevant time. And on the top of everything, your lordship kindly see the the
These
witnesses,
documents at serial number 4, 5, 6, and 7, was it verified
4, 5, 6, and 7.
in the material exhibit 3?
That has not been supplied.
You asked the defense side if they verified the documents as listed by their PO. The defense has replied that they verified the documents and submitted certificate to that effect. Now, the documents which are relevant for the disciplinary proceeding, he has said, he has inspected and he has verified. And now, apart from that, my lord, when the MW 1 and 2 were produced, my lord, he was asked by the inquiry officer whether he will cross-examine. He said in regard to all the charges, he said, no, I am not going to cross-examine. That apart, my lord, he did not give any evidence. He was asked whether you want to further give any evidence. He said, no, I don't want to give anything.
That part I'll
Now,
reply.
this
to.
is the position, my lord.
That part, my lord, I'll reply because until and unless documents are supplied to me, my lord, I cannot say, my lord, what is that about? If the document is used against me, my lord, I am entitled for the inspection as well as the copies.
What relevance has these documents 4, 5, 6, and 7? What
It
are
is
these?
relating to the departmental proceeding, they said, my lord, most probably my guesswork.
Huh?
Because the person he died, in accident. Whatever guesswork I can make out from the,
Guesswork will not help here. What
my lord,
guesswork?
relating to the departmental proceeding.
Uh,
What is that about exactly? I cannot say. Record will reveal, my lord. That these documents was not given to me, my lord. Again, page 100.
Are these
one,
documents available in the record, Mr. Doctor? 4, 5, 6, and 7? What are these documents that he says he was not received?
Lordship picture will be clear, 101 page.
Mhm.
Lord, can I hand it over to your lordship, my lord?
No, you look into it. I think,
Lordship,
what is this?
This I'll just look into it.
Lordship, kindly have a look, 101 page.
What is in this seal cover?
This is the proceeding book, my lord.
Why have you kept it in a seal cover?
Just for the honorable court to look into all that.
So with your permission, may we open it?
No, my lord. Your lordship is all in all.
There are a file go to Bank.
4, 5, 6, these are all given. My lord. The record will show.
No, what are these documents? That's what I'm asking you.
Yes, my lord.
Pertaining to material exhibit 3.
My lord, your lordship can do one thing.
Hmm.
In a one go, let the entire matter be over. Let the matter be fixed for hearing. My lord.
That is what we thought we are doing.
My lord, I am a widow, my lord. I am not getting anything, my.
All right, you
My
tell
lord,
us when you want the matter to be.
Getting a thing is a different issue, my lord. If he is eligible, he will get.
My
If
lord.
he is not, he will not get anything. But then it's a order of dismissal. If your lordship look into the charges, very, very alarming, my lord. In all the charges, my lord, what he has done, My
No,
lord,
no, he has made a specific statement that there are certain documents which were never furnished to him.
111 will be more clear, my lord. Lordship kindly
100?
come to 101.
101, yes.
Well, Lordship kindly see. They have received, they're putting their seal also. Prayer for the certificate copies of document number so and so. I hereby beg to state you that regarding the subject matter side, I have already made correspondence addressed to you by letter under reference, which is shall be for your ready reference. The same is enclosed here which for the so and so noteworthy to despite of request made by said letter as well as the last inquiry sitting on 18/3/20. Yet I have not received a single copy of the document requested to record the side of the correspondence in the last proceeding, but was ignored and is not recorded. Thus, once again, I humbly request you to provide the furnish me the certificate copies of all the papers.
Was any direction issued for recovery?
No, no,
Only dismissal?
simply my lord dismissed.
my lord, this letter has got no significance because your lordship will see the
Let me
disciplinary
complete, my lord,
proceeding
my
record
learned friend will
18-3.
get ample chance to reply.
Very well,
18-3, he has inspected all the documents.
Well, if you want some other date to argue the matter.
My lord, better let's get all these things clear.
Yes. You tell us a date.
Lord,
Any Tuesday, Thursday, Lord. And because I'm a widow, my lord, and I'm very difficult to survive at this stage. And he died of accident during pendency of the appeal, before department, lordship may come across, my lord, one scooter was hit near to the Assam Engineering College.
these are all sympathetical
Not
arguments. my
saying I
lord. We are-
don't want any sympathy, my lord. I'm
we are
very
not concerned
worried
at
of
all.
the
on
case, my lord. Widow is fighting like
that.
anything.
If the law permits, he will get everything. My lord, it's all dependent on the
I'm
legal
not
position.
making any sympathetical submission, man. I
We-
said, my
we'll
lord,
take it,
why
we'll take it up.
this
Give a date.
widow is
Call it date.
fighting?
Date.
Any Tuesday, Thursday,
September 9,
short date, my lord.
28. 28. Let's have it on 28th of September.
28, it's okay.
You can take back these
My lord, yeah.
records and give it to us on
Right.
that particular day. Report to regular.
And adherence to the, my lord, their service law, that also not been, that all come subsequently.
We do.
In regard to my lord, regulation
Correct.
18 and 20, that speaks only that when you are a bank officer, you'll have to do your job most honestly and with all integrity. Now 18 and 20 speaks about that one.
Learned counsels for the parties are agreed that the matter should be taken up for a final disposal on a fixed date. Accordingly, list again, as agreed to, list again on 28. 28/9
God bless.
for admission hearing. Yes.
Lordship, as per the last court order, I have to produce the inquiry report, Lordship. With the inquiry.
The inquiry was not served upon him.
No. Yeah, they were being served, Lordship.
They were served.
Lordship,
We were not served, your lordship.
there is a office record, Lordship. As I have been informed over telephone. Served করা।
In their affidavit, they have not said, your lordship, that we have been served. They only say, your lordship,
May I pray before your Lordship that Lordship may remand back the matter to the council, Lordship, let the authority decides
For
for a fresh consideration of their prayer, Lordship.
what is your prayer here?
lordship for your lordship. Passing of the order of termination as well as the order, your lordship, by which your lordship.
Then you'll have to take them, they'll have to be taken back into service.
Lordship, let the council authority decide, Lordship.
No, there's, for remand, we'll have to set aside the orders.
Okay. No, Lordship.
How else do we remand it? For what purpose?
For fresh consideration, Lordship.
So fresh consideration means the earlier consideration will have to be interfered with. Where is the impugned order?
Your lordship. The order of the appellate authority is page 36. And the order, your lordship,
33.
page 23.
Where is the record to show that this inquiry report was served upon them? You have the records?
Lordship, today morning I have been informed over telephone, Lordship, by the joint secretary that they were being served with a copy of the report. Since
On what basis? Is there any evidence to, is there any reflection in the records?
Lordship,
How were they served?
Lordship, I will bring it on record if your Lordship permit me.
Last occasion they have. the
Lordship,
report in
last
mind.
occasion I have sought for the inquiry report, Lordship. I have sought the time for inquiry, producing the inquiry report, and this is the inquiry report.
Let him get on record.
Lordship,
Mr. R.M. Das, learned counsel appearing for NC Hills,
Lordship,
submits that you'd like to bring the inquiry report on record by way of an affidavit.
Lordship.
Stop. Mr. Bothakur, learned counsel for the petitioner, submits that the inquiry report was never served on the petitioners. In that view of the matter, the learned standing counsel will also bring on record the manner in which the inquiry report, if at all, was served on the petitioner in the affidavit which he craves leave of the court to file. Let the affidavit be filed within 2 weeks from today.
Your lordship, will fix a date, your lord.
Give a date.
Lordship.
Yeah, please, Your Lordship. My lord, in the last occasion, my lord, we are directed to file additional affidavit regarding the status of the daughter of the petitioner as well as the respondent, my lord, private respondent. Accordingly, we have filed, my lord.
This is a matter of two wives.
Yes, two wives.
You are for the second wife,
No, I am the first wife.
first wife. And you are for the second wife.
Lordship, I'm for the second one.
My lord, already we have filed a joint affidavit, my lord, declaring our status, my lord.
Where is that affidavit?
Joint affidavit is there, my lord. Plus serial case 83.
Yes. Yes. Yes, what do you say? You
Lordship,
agree?
We have joint affidavit, we have agreed, Lordship.
So you are agreeable to payment of death cum retirement gratuity
Lordship,
and gratuity.
Lordship.
But the authorities can't pay you that, you'll have to pay that. How can the authorities pay the second wife? Because in the documents, your name,
We are not, my lord, here, my lord, second wife declared that she is not entitled. But we have
Daughters.
also admitted that we are ready to pay the, my lord, share the DCGR amount among the, my lord, daughter of the deceased person. my lord.
what other amounts are receivable?
My lord, amount is reflected, my lord, in page, my lord, 28. Page 28, my lord. Next of 4, my lord. Family pension, this is here, GPF, GIS insurance and leave encashment benefit, my lord. These are the amount.
Yes, who's for the respondents? Anything to submit?
So I'm appearing for the department, actually, because Mr. P Nayak is appearing. I'm on his behalf, Mr. P Nayak. He's actually he's on Lex in the different court, my lord.
You are there, you argue.
My lord, he's leading the case, my lord. I'm not in this matter.
Can we help if he's not here?
Can be taken up after some time, my lord.
No. No, because, yes, Mr. Bhagavati?
Lordship, everything is in order, Lordship, as per the
Joint affidavit.
joint affidavit, Lordship. Everything legally,
But the question is,
Lordship,
how can the authority release
Lordship.
that amount which you have agreed in your name?
No, not my name. My wife cannot get Lordship. I mean, the second wife cannot get Lordship. Second wife, but the daughters can get Lordship. Daughters will be eligible, Lordship.
No, but you have sworn in this affidavit.
Lordship. Lordship, that will be done as per law by the office, Lordship.
What does the law say?
Law says, Lordship, that the daughters, even if it is the second wife or illegitimate children also, Lordship,
Show us the.
they will be entitled.
Show us, show us.
Lordship,
Show us the law.
Lordship, that is in the
Pension rules.
Pension rule.
pension rules, Lordship, 136, I think, Lordship. 135, 136.
136.
136, Lordship. Lordship, 136, Lordship, 1, 2, 3, 4. They are all eligible, Lordship. This year, G. That is the wife in case of a male officer, husband in case of a female officer, sons, unmarried and widowed daughters, Lordship.
No, this is first a wife
Lordship.
or a husband.
First wife will get, Lordship.
The first person to receive would be the spouse,
That's it.
whether a husband or a wife.
Lordship.
In the event of their death,
Lordship.
comes the sons, if they're not
Lordship.
major.
Lordship.
Then comes unmarried daughters.
Lordship, it is in 135, Lordship, this year, G.
We agree with that. There's no dispute. What I'm asking you
Lordship.
is, these are the legal heirs. How is the amount to be distributed?
Lordship, there is the first wife.
This purpose of family is
That's
for
it.
the purpose of pension and other benefits.
This year is not family, Lordship.
Family for the purposes of this rule.
Lordship. Family for this rule. That will be done as per the rule, Lordship.
So that is what I'm asking you.
Lordship. The usual way they do, Lordship, the office.
It is because the office has not done that you are before this court.
No, Lordship, the officers have made a mistake, Lordship. They wanted to give me, the second wife, the family pension, Lordship. I said, I say that I'm not entitled for that. I have clarified it, that the
What
second
I'm
wife
asking
is not
you
entitled.
is in view of this joint affidavit,
Lordship,
where is the provision under the rules to say that the amounts should be directly released to the sons and daughters? Under what provision? amounts will be released to the legal heir,
Lordship,
who as on date is the first wife.
Lordship,
Now the first wife may release it to
the others, Lordship.
others.
Lordship, I understand what Lordship says, that the first wife will get it,
There is
Lordship.
no specific provision here that
Lordship.
sons and daughters will, amount will
Lordship,
be
some
released
legal-
separately.
Lordship, someone should collect it for on behalf of the others. That is it. I understand, Lordship. Lordship, we have
We
given,
can close it on the basis of the undertaking given. That's all.
Lordship. That will also do law, because there is an undertaking. And if. Lordship, what he says, if the first wife gets the amount, he undertakes that it will be shared among the eligible.
That is what I said.
Yes,
We-
that's it.
On the basis of the undertaking, we can close it.
Lordship,
But that we cannot issue a direction to the department to release the payment directly to the sons and daughters on the basis
Lordship,
of the
Lordship,
undertaking.
I understand, I understand. I understand.
If you are agreeable, we can close it.
Lordship, Lordship. We are agreed.
Are you sure?
Lordship, actually, we had an understanding, Lordship. Initially, we didn't, Lordship. Even I forfeit, I said that I am not entitled for the family pension. That I have clarified, so that the first wife gets it, Lordship. A good gesture from the second wife. I told her that you are
There
not.
is a judgment of, I think, a division bench or a full bench, where the parting observation is there.
Lordship, that I think is for the Muslim law.
Even for regular pension, in cases of disputes.
In the recently delivered judgment of the pertaining to Muslim law.
No, that
Even
is the
the-
separate.
That
That's
also
full
there is an issue, Lordship.
Full bench,
Full bench,
you are
Lordship.
referring to the full bench judgment.
Lordship, there is also an issue, Lordship, that was, I think, not reflected clearly. One thing should have come. After the first wife gets it, if she doesn't distribute the amount, what will happen?
There is no law. That is what I am asking you.
Lordship,
That is what I am
that
asking.
should have been reflected in that order.
How?
So that is the problem, Lordship.
There, the pension is strictly governed by the rules.
Lordship,
Whatever the rules say. Family has been defined, but
Lordship,
there is no definition to say that it will be apportioned amongst the family at the same time. You point out any provision that it is there. So we can close it on the basis of
Lordship,
this undertaking.
Lordship,
You are recording the undertaking, Mr. Sinha.
Lordship.
Regarding this is your amount.
And failure to honor an undertaking given to court amounts to
yes.
contempt.
Lordship.
And it is amount regarding this is your amount then. My-
Whatever you stated in the
Yes,
joint
yes.
affidavit. Heard learned counsels for the parties. This writ petition is filed by the petitioner who claims to be the first wife, legally wedded, legally married, legally wedded wife of one late Bokhanto Kumar Pushya, since deceased. Stop. According to the petitioner, the marriage was solemnized on 5/4/1981 as per Hindu religious rites. And the marriage was solemnized socially. And they started residing in the matrimonial house of the deceased husband, situated at Dolibari. In the district of Kamrup Rural. Stop. The late husband of the petitioner was working as a grade 4 employee peon, within bracket peon, in the office of the Deputy Secretary, Government of Assam, Secretariat Administration within bracket Nazara, bracket close Department, Dispur, Assam. Stop. Out of the marriage, 2 daughters were born on 1/10/1982 and 12/12/1985 respectively. Stop. It is stated that after the birth of the second child, the late husband of the petitioner left her and their children suddenly and went away, causing great hardship to the petitioner in sustaining her along with the two small children. Stop. Subsequently, the petitioner came to be informed that her husband had remarried with the respondent number 6, and out of their marriage, 4 children were born.
My lord, 3 children are there.
You stated 4,
Yes, my lord, that's particular mistake.
3 or 4,
3, my
He was
lord.
not aware at that time,
At
they
that
were
time.
not aware, Lordship. I clarified that there were 3 children.
3 children
For-
were born. Stop. Upon being aware of the second marriage of the husband of the petitioner with private respondent number 6, the petitioner approached the court by filing applications under section 125 CRPC for maintenance. Stop. The maintenance was accordingly ordered by the competent court, and subsequently on her application, it was also enhanced. Stop. The petitioner's husband expired on 15/4/2013, and the petitioner thereafter applied on and claimed for the deceased husband's retirement benefits. Stop. A succession certificate was also obtained by the petitioner from the competent court of civil jurisdiction. Stop. Where is the order, impugned order?
My lord. Page, annex 4, page 28. my lord.
The petitioner is aggrieved by the impugned order number so and so dated 7th May 2015, which was issued by the respondent authorities in favor of the respondent number 6. Is it 6 or 5?
My lord, 6.
Respondent number 6. Forwarding all the pensionary benefits in respect of late Bhakanta Kumar Bushyo in favor of the respondent number 6. So, in terms of the communication dated 7th May 2015, the matter was being processed when the petitioner has approached this court. Stop. She had earlier filed WPC 3407/2015, which however was permitted to be withdrawn with liberty by order dated 16/11/2017. Stop. The matter was contested by the respective respondents, disputing the claims of the petitioner. Stop. While the matter was pending, both the parties, both the petitioner and the respondents have arrived at an agreement and have jointly filed an affidavit on 25 August 2023. as per the said affidavit, the petitioner who had filed the joint affidavit as the petitioner had agreed to part with the share of DCRG amounting to rupees 1,68,345 amongst all the legal heirs of her late husband, Pokhanda Kumar Bushya. Stop. Learned counsels for the parties submit jointly that in view of the agreement arrived at between the petitioner and the respondent number 6, both the parties have amicably settled the matter as reflected in the joint affidavit, and the petitioner has agreed to part with the DCRG amount of 168,345 amongst all the legal heirs of late Pokhanda Kumar Bushya. Well, learned counsel for the parties have been heard. The pleadings on record has been carefully perused. Anything to submit from the government? The impugned order number so-and-so dated 7th May 2015 reads as under page number 28 extract. Upon perusal of the pleadings on record, it is seen that there is no dispute that late Pokhanda Kumar Bushya had remarried respondent number 6. Now entered into a marriage with respondent number 6 during the lifetime of the petitioner. Stop. There is also no dispute that 3 children were born out of the said marriage between the petitioner and the respondent number 6. How old are they?
Lordship, they are measured, like I have given.
All right. The said evermens are not disputed by the counsel for the petitioner. Stop. There is also no dispute that from the pleadings, it is evident that petitioner is the legally wedded wife of the deceased so-and-so. Under such circumstances, it is the petitioner who is entitled to the pensionary benefits of a late husband in terms of the provisions of the Assam Services Pension Rules 1969. Stop. The authorities are duty bound to release the pensionary benefits in favor of the petitioner. In terms of the provisions of the pension, some pension rules. Is there any affidavit filed with the government? Any affidavit by the government?
I don't think they have filed a Another thing, Lordship, the second wife, daughter, had got compassionate upon me, Lordship, by process, Lordship, due process.
How is it relevant?
So they do not have any grievance against her, Lord. That is also reflected
In the
in the joint
reflected-
affidavit, Lordship.
your affidavit.
Joint
affidavit.
one, Lordship.
Page 48, my lord, para 4, last line.
Government has not filed affidavit.
No lordship.
This court. By order dated. Seven five 2018. While issuing notice. Directed in the order, in the interim, that if money had not been disbursed to the respondent number 6 in terms of the impugned order dated 7/5/2000, in terms of the order dated 7/5/2015 within bracket annexure 4, then status quo was directed to be maintained on disbursal of the superannuation dues to be maintained until the returnable date. The said order was continued. The said interim order was continued upon extension. While the matter was thus situated, it is reflected in the order dated 7/9/2023 as well as in the joint affidavit filed by the petitioner and the respondent number 6 that the daughter of one of the daughter of the respondent number 6 born out of the wedlock of late Bohondo Umar Boisho and respondent number 6, namely so and so, was appointed on compassionate ground in the because of the death of late Bohondo Umar Boisho while he was in service. Stop. Be it as it may, in the absence of any affidavit filed by the respondent department, it is not evident as to why, as to how the respondent authorities came to issue the impugned order number so and so dated 7th of May 2015. Whereby the pensionary benefits were being processed in favor of the respondent number 6. Stop. Under such circumstances, taking the submissions made by the learned counsel for the petitioner as well as for the respondent number 6, and more particularly taking on into consideration the joint affidavit filed by petitioner and respondent number 6. Joint affidavit dated. Where is that affidavit?
Page 83, madam.
Page number
83.
83. Joint affidavit filed by petitioner and respondent number 6 on 25 August 2023. The writ petition stands closed, directing the respondent authorities to release the pensionary benefits in favor of the petitioner as she's both parties are agreed to the submission that she is the legally wedded wife of the petitioner of the deceased late so and so. Stop. However, we take on record these statements made by the counsel by the petitioner that by way of the joint affidavit executed on 25/8/2023 that she has no objection if the authority gives the share of DCRG amount of rupees 168 345 amongst all the legal heirs of it, Pahondo Umar Bush. Learned counsel for the petitioner submits that this averment means, this averment made in the joint affidavit should be taken as an averment made by the petitioner not to claim the amount of rupees DCR, rupees so and so as DCRG, and give up her claim in favor of the respondent number 6. Stop. Accordingly, the respondents, official respondents are now directed to release the amount of pensionary benefits, including DCRG, in favor of the petitioner. And upon receipt of such amount, the petitioner will, in terms of the averments made in the joint affidavit, will release the same in favor of the petitioner within a period of 30 days from the date of receipt of the said amount. The release of the pensionary benefits by the respondents in favor of the petitioner 1 will also be intimated to the respondent number 6. Stop. In the said affidavit, it is also recorded that the petitioner number 1 will not take any steps in future against the daughter of the respondent number 6, who has been appointed in compassionate appointment, who has been given compassionate appointment. Stop. The writ petition stands disposed of in terms of the above. The authorities will release the pensionary benefits in favor of respondent number 1 within 30 days.
2 months.
60 days from the date of receipt of a certified copy of this order. I don't know if even Panchayat passes this kind of orders.
So this is a contemplation against violation of the order dated 22/1/2019. Alien portion is at page 13. Directed to provincialize the services of the petitioner, last operative portion, page 17, within a 2-month period from date of receipt of the copy. Followed accordingly, we communicated to the authority. And the annexa BCDRD letter to the concerned authority. But till that, the order has not been complied of. And during the pendency of the case, now the incumbent has retired. So I impeded the twice, 2 implemented petition has been filed. And copies were served to the concerned. SMT still allocation here appears always.
Which department is this?
It's a secondary department, petitioner.
Secondary education. Who appears for secondary education?
And Mr. Sisti's name is shown.
Yes,
in the-
Mr. Dhar.
There are names in the.
There are names, but they have not appeared. So
My lord, that is what I'm just informing this council's my lord.
On
what is
behalf
there
of
to inform?
SMT, your lordship, respondent number 1, your lordship, I am appearing, your lordship.
Yes, what do you say? Why order not complied with?
Your lordship, I am not on the records. I will inform him, your lordship. So kindly pass over the matter for time being, your lordship.
All right, on Friday.
I'm
There
deeply
is
obliged.
urgency, my lord. There is
Friday.
Friday.
my lord.
Friday.
Deeply obliged.
Learned counsel stated to be representing respondents is not present in court. Matter to be listed on Friday, 15th.
Lordship, I am appearing, your lordship, for respondent number 1. your
You said you're not on record.
Not on records, your lordship.
What
but
is the
I am
meaning of
appearing
that?
On behalf of SMT, your lordship.
On behalf of.
Either you submit or
No
you,
power.
this is a contempt proceeding.
Yes, your
Do you have any power? She has not filed any
You have
power.
not filed any wakalat. Mr. UK Goswami for the petitioner on 15th.
deeply obliged.
Lordship had heard this matter earlier. The respondent number 3 did not appear, Lordship, and
My lord will recollect that matter wherein my lord had directed us to take dusty service. We had taken dusty service. He has to the office, my lord. He has received it, but my lord, I don't think my lord. He has got his dues, my lord. Maybe that's why he's not interested, but he has received it. My lord
Where
would
is,
have it.
where is the receipt?
My lord would have it at
That affidavit dated 12 September.
12th September, today's. My lord would have it at page 70. My lord. This is a receipt which he had given to the Director General of Civil Defense. He received it on 28/8, and the order of the court also was, my lord, a part of that, wherein, my lord, today's date was fixed.
All right.
My lord can have it for final disposal. My lord,
Yes,
within date.
we'll have it for final disposal. This is a case for promotion.
Promotion, my lord. I have challenged the encadrement of the private respondent.
He was a telecom operator,
PBS operator,
PVX.
PBX operator. He was encadred by the Director General, not by the government.
Now, are there any posts available now?
My
You
lord,
are
what had
promoted
happened-
in the meantime.
I was given 2 promotions, my lord. But the problem was because of the pendency of the proceedings, they did not promote anyone. They promoted me subsequently on a later date, my lord. Whereas these vacancies were there from a prior date. Because of that, one more promotion that I'm due, my lord, Deputy Director, that I will not be able, because I'm retiring. March.
So what are your prayers to?
My prayer would be, my lord, to interfere with that, my lord,
That order,
order,
encouraging him.
lordship.
And then,
Then, my lord, I come up at serial number 1.
No,
Then, my
no.
lord, I'm
you'll not come up at serial number 1. It has to be
3,
the redone.
redone the whole exercise from that date, my lord.
Hmm.
A review DPC, my lord, with effect from the vacancy was due. Because they did not promote me because of the pendency of this.
All right, we'll give one more date.
Lordship.
This gentleman, if he wants to appeal.
Lordship.
Heard Mr. UK Nair, and senior counsel assisted by Mr.
MP Sharma. MP Sharma.
It is submitted by the learned senior counsel that pursuant to the orders of this court dated 10/8/2023, whereby dusty service was permitted to be effected on the private respondent number so and so. What is the number?
3.
Private respondent number
3.
3. Dusty service was taken by the petitioner and through the office of the respondents, and the respondent number 3 has acknowledged the receipt of these copies by a communication dated 28/08/2023. Addressed to the Director General, Civil Defense and Commandant General of the Home Guards, Assam. Stop. In that view of the matter, stop. However, no counsel represents the respondent number 3 today. Accordingly, in order to enable the respondent number 3 to enter appearance in terms of the services affected under orders of this court, matter stands adjourned. Matter stands deferred to 22nd.
Lordship.
22nd. It's 22nd. Mr. Ardhor appears for the respondent. Authority, 1 and 2.
My lord, I think this petitioner is no more interested in this case because I received a call because there was a direction from this court as to seek instruction regarding that, my lord, appellate authority, my lord, whether they have taken it up. So, my lord, this petitioner's wife called me up. She is also an officer in the PWD, and she told me that already husband is retired. He got a promotion after that 2 years. And not interested in the case. So I told her that you advise your counsel to come and at least withdraw the matter. This was some 1 hour back, my lord. So that is the thing, my lord, I can say, my lord.
None appears for the petitioner on call. Mr. Ardhor appears for the respondent. PWD.
I'm for the respondent 5.
Mr.
Sending in for Mr. T. Bharadwaj and Mr. D. Bharadwaj.
Mr. So-and-so appears for respondent number 5. On 22/8/2023, none had appeared when the matter was called up. On 29/8/2023, none has appeared when the matter was called up. Accordingly, this court, matter stands dismissed for non-prosecution. The interim order, if any, stands vacated.
Yeah, please, Your Lordship. Lordship, the matter pertains to Your Lordship selection and appointment in the cadre of the Deputy Director, Your Lordship. Your Lordship, here we need to produce application forms of the candidates, Your Lordship. The records we needed to produce, Your Lordship. So kindly.
Why
grant us-
application forms are necessary?
My lord, we have alleged that the persons who have been
Yes, Your
appointed,
Lordship.
they have been appointed in clear violation of the rules with
Rules.
false documents. Then, my lord, in the writ petition, my lord will not find much particulars. We had filed additional affidavits. Copies were given to all in terms of the directions of this honorable court. And today I have been informed, my lord, that a criminal case was also registered pertaining to the same selection process. And therein charge sheets have been filed against some of the private respondents.
So what is the challenge?
Challenges to their appointment, my lord.
Appointment.
Appointment order.
Appointments.
Appointment to what post?
Post of, my lord,
Cadre.
Assistant Inspector of Schools.
Deputy-
Inspector of Schools,
Deputy
Deputy
Director.
Director, sorry,
Director.
Deputy Director, Inspector of Schools.
You are working as?
No, I was a party, my lord, because of the illegal appointments made, my from
Yes, yes,
seniority, my lord, my merit position was depressed, my
No, this is a direct recruit.
direct recruit.
Who's for the respondent
My lord,
education?
number of advocates have appeared,
Secondary education.
secondary.
I'm appearing, Your Lordship, for on behalf of secondary education.
I'm for the appeal.
My lord, this was asked to produce the, my lord, record.
Records.
I'm going to record.
Fine.
What records?
Records, my lord, the applications, my lord,
Forms.
and the distribution of mark, my lord. That is in the record.
What is your primary challenge?
Primary challenge, my lord, would be with regard to, my lord, 4-5 aspects. One, that there was a requirement in the, my lord, the advertisement that persons in service have to apply through proper channel. The private respondents have not applied through proper channel. One,
They were employed.
they were employed, my lord. Two, my lord would find certain certificates which were given. My lord, those certificates were subsequently, my lord, we have established that those certificates were, my lord, forged. Experience certificates. But an experience criteria was also there. That would be applicable for respondent number 4, 6, 8, 11, 12.
How many posts were
The
advertised?
advertisement was for, my lord, in total. Sixteen posts. my lord.
Deputy Director,
Deputy Director, Inspector of Schools.
Inspector of Schools. You are only for this serial number 2
I am for, my lord,
in
petitioners.
the advertisement.
Lordship. Then, my lord, there is a criteria that you have to give marks for uniformly brilliant academic career. But my lord would find what the brilliant academic career was and how APSC has marked for them. Third division marks, given very high marks. Third division in HSLC or HS, given very high marks, my lord. Respondent number 17, he got grace marks in HSLC, but he has been marked very highly. Because the distribution of marks was, my lord, 50% for academics and experience and 50% for, my lord, interview.
Now, this advertisement is for
16
various posts.
various posts. We are only concerned with page 29, serial number 2. 16. Sorry, my lord. It's serial number 3, my lord. 15 posts are Inspector of Schools, so and so. Listen, Inspector of Schools. Sorry, my lord. 2, serial number 2. Deputy Director, Inspector of Schools. The next one is Assistant Inspector of Schools. We are not concerned with that. And my lord will see the educational qualification. Second class master degree having uniformly brilliant career and possessing teaching experience in school or college for 10 years or administrative experience of 10 years, of which 5 years must be teaching. So these certificates that were produced, my lord, the RTI replies are there from the schools. Wherein, my lord, they have said that those certificates were not issued there.
So are the respondents represent?
All respondents.
Okay.
Today, I have not seen much, but everybody is there. My senior Mr. Nath is also there, my lord.
Are the representations before the court in actual or they're also?
No, they are actual here.
They're actual.
They're actual.
Yes, Mr. Nath, what do you say?
Complete his argument, I think. There are a lot of many respondent concerns are there.
His arguments are complete. It's that your documents are forged.
He's not saying for everybody. Maybe for particular 1 and 2, not for everybody.
No, 4, 6,
So
8,
I am
11.
concerned. I don't think my submission is not clear.
And the respondent, my lord, may also be directed to produce that charge sheet, my lord, which has been filed by the police in the matter.
Who has filed it?
The CID, no? CID.
Who has filed the FIR?
The FIR was by the,
Education.
some candidates have filed it. Not me, but some others.
Yes, education. Where is your affidavit?
Affidavit has been filed, your lordship.
Let us see your affidavit.
Four. Number 2.
Where are the averments that the documents are forged?
Lordship. My lord will have the additional affidavits.
Oh, additional affidavit.
I'm sorry, my lord, it's not numbered here. Additional affidavit, my lord, dated 5/10/2013. WPC number 4325/2012.
WPC
4325.
4325.
I have filed
Four, three, two.
additional respondent
In which matter?
325 of
4325 निकालो भाई.
My lord will have page 8 of that.
Page 8 of
Of that additional affidavit dated 5/10/2013. I'll have the, my lord, numberings made, my lord. That will be helpful. It'll probably be-
4325.
Lordship,
There is no additional affidavit.
yes, your lordship.
It is
Hiranyakumar
in the
Nath.
court's file, it is not there.
There might be in a separate file.
an affidavit respondent 5 Josnarani Burman. I have filed.
No, no, no.
Your affidavit is also not there.
No, there was heard, man, it was there.
Yes, 4325 is there.
Yeah, देखो.
4325 was, maybe it's.
4325.
Oblique 12.
तो दूसरा फाइल है ना. फाइल देखते पूरा कंप्लीट फाइल देना चाहिए ना. Yes.
My lord will have the affidavit dated 5/10/2013. Hiranyakumar Nath. Page 8 thereof.
Hiranyakumar affidavit in reply.
No, there is an affidavit, additional affidavit.
5th October.
5th
2013.
Lordship, 5th October 2013. My lord will have page 8,
Page 8.
para 8. That the whole selection process turned into a mockery due to submission of fourth certificates, mostly with regard to teaching experience, which was a compulsory experience required to be possessed by many selected candidates, which proves that instead of merit and eligibility, it was some extraneous considerations which played a pivotal role in selection of candidates as APSC without any scrutiny accepted such post certificates. The list starts with respondent number 4, Anjan Kumar Deka, the first position holder in the merit list, who submitted an experience certificate of 5 years, 10 months, 21 days, purportedly issued by in-charge principal TU College on so-and-so. But in response to an RTI application of the petitioner, the in-charge principal of so-and-so by a communication dated so-and-so to the principal of so-and-so, dated so-and-so, clarified that never worked in TSU College as lecturer for the relevant period, and writing of the certificate, college pad and signature on the certificate are all forged and fabricated one. It is seen that the certificate by experience certificate obtained by respondent number 4 from so-and-so, body period so-and-so, so-and-so is also forged, as during the relevant period, he was pursuing BSc, MSc as a regular student. It was not possible for a person to become a regular service holder and a regular student at the same time. Then my lord would have.
And what is the response of the respondents?
The respondent number 4, my lord would find in the affidavit. They have filed an affidavit. my lord.
You are now serving as?
We are serving in schools. my lord. One of them is serving in a school. and
As?
they are- As a teacher, subject teacher.
So in response to your additional affidavit, has further
Lordship.
affidavits been filed?
Lordship. The government has also filed an affidavit. The respondent number 4's affidavit, my lord. Yes, it is dated 1/8/2013. at page 3, para 11. my lord. Anjan Kumar Deka. It's a affidavit dated 1/8/2013.
One eight.
1/8/2013. My lord will may find it in the repetition file also.
There is one filed on 26th of June,
13,
2014.
14. My lord would have that 1/8/2000. My lord, I'll do one thing, my lord, I'll have those things serialized, man. That will be
8th of June is
1/8/2013.
1/8.
1/8. I received it on 1/8. 1st of August 2013. My lord, the respondent number 4 is Anjan Kumar Deka.
Yes, that's what we had. This is 26th June. Don't know. Anyway,
Maybe, my lord. Maybe he has filed it.
this is in response to the additional.
Additional
affidavit.
affidavits, my lord.
Yes.
My lord, para 8, the reply.
Sorry, there is. This is
Nothing
some
there.
other affidavit, but filed by the same person against the same affidavit.
But here, therein, my lord, in that 1/8/2013 affidavit, with regard to that experience certificate, he says, I'll just read it, my lord. That with regard to the statement wherein so and so the repetition, the deponent begs to say that it's the APSC that decides the admissibility of the experience certificate of the candidates. The petitioners have no role to play in this regard. In the instant case, APSC has accepted the experience certificate of the deponent. As such, if the petitioners have doubt about the veracity of the said certificate, they may be put to strict proof thereof. That much only. But the RTI replies and all came, my lord, subsequently in the additional affidavit. And
But that will require proper verification.
because I have given an RTI reply, my lord, that shows prima facie that the certificate that was issued, the author and the college both says that this was not issued by him. There was no such person working. And today I'm told, my lord, that against him also a charge sheet has been filed. That serial number 1.
So what about the charge sheet?
If the government can, my lord, place that before my lord.
Yes. Who's filed the charge sheet?
CID. CID Assam.
And
Lord-
what records do you want to produce? What records?
My lord, in my lord, original application and my lord, the distribution of marks.
That original application will contain the marks, the certificates.
Lordship.
Application. Yes, my lord, with application, my lord.
Now, if the CID has conducted some inquiry, investigation and filed a charge sheet, these documents were not examined.
My lord, that part is, my lord, in the government will. My lord, the original documents, certain original documents are with the CID. Well, government is in better position to produce the.
Who is representing the government? That is what we are trying to find out for the last 5 minutes.
Government, my lord, Mr. Bora can represent me.
Lordship, on last occasion, your lordship, we wrote to them on 21st of August,
To whom?
the Director General of Police, CID, seeking basically place the up-to-date status report along with the relevant instructions. But they have still not given us any kind of. So some time will be granted, I'll inquire.
Because now the charge sheet.
Lordship, my submission is that insofar as I am concerned, no case is made out against me. I'm respondent 5. The basic allegation is that the candidate do not have the required qualifications, and secondly, they did not apply through proper channel. So in my case, I have the para 5 and 6, if you allow to me read.
Of your affidavit.
Of affidavit 4325/2012 writ petition.
Filed on behalf of
On behalf of Jyotsna Rani Burman, respondent number 5.
respondent 5.
I'm still working as a subject teacher.
My appointment stays in. My appointment stays in. Okay. Pune? Jyotsna Rani, no, respond number 5. 5.
But prima facie, Mr. Nair,
Lordship.
unless there is a finding, does it not amount to disputed question of law? Fact.
My lord, the documents that I have brought on record, my lord. Now, my lord, if the charge sheet also, my lord, reveals that fact.
No, but it is a charge sheet.
Charge sheet, fine, my lord.
There's
But
no,
at least, my lord, there are materials which the government and the APSC must have, my lord,
which
should
will
have
be
verified.
made subject to outcome of such orders as may be passed by the competent court.
Lordship. But the thing remains, my lord, that if there is a allegation, my lord, they are bound to, my lord, look into it.
No, that allegation, there are the department, competent department required to investigate into the matter is already looking into it. They have already filed charge sheet.
But my lord, that will not negate the allegations which I have labeled for, my lord.
These are
removing them.
allegations. So
These allegations, my lord, go to the root of it, my lord. The very selection, my lord, is questionable. The whole selection process is questionable.
your affidavit is not available.
My lord, there are some documentary this thing, my lord, because it's an old file. I'll get it serialized.
You don't have to take the trouble. We'll direct the registry to do it.
Then I'll also be helpful.
But essentially, your allegation is that these documents are
One
forged.
One
But that
allegation.
forgery
Lordship.
will have to be established.
No, what I'm trying, because my lord, the RTI application is already there. And
RTI
they have
is
not
there.
denied that.
RTI is there. RTI would reveal that so-and-so made a statement that he or she did not issue that document. Is it enough to return a finding that
My lord,
document forged?
my humble submission would be,
Prima facie, yes, there is a suspicion. There is a suspicion.
my lord will.
Now the
if that
matter
be
is
so,
under
if that be-
investigation.
That be so, my lord. My lord can direct the concerned authority, either the education department or the APSC, to verify those facts. if those facts are verified, they can take, my lord, an action in their own way.
That investigation is already
No,
undertaken.
that would take its own course, my lord. Whatever is to be done, it will be done.
Hmm.
6, 7 people. Then, my lord, the condition in the advertisement is that you will have to apply through proper channel. They had submitted application direct. So they accepted it. APSC accepted it. So that was in violation of the conditions of the, my lord, advertisement. Uniformly brilliant career. A third division candidate giving marksman. Because the distribution of marksman,
So how many petitioners are there?
there are, my lord, 3.
3 petitioners. So your claim is to 3 posts.
Basically. I can't go beyond that. But for coming to that 3 posts, my lord, these persons who have been brought in or hoisted above me have to be removed.
How many respondents are there?
There are in total 16,
16.
lordship.
So from 16 will go up.
I'll go up, my lord. I'll come in within the, I'll be appointed.
Who's appearing for 14, 15, 16?
Saju.
I am lordship from 15.
15, then 14.
In WPC 4225, my lord, I am appearing on behalf of 8, 10 and 14.
14. Okay, and 16. No, there are others also. 17, 18, 19,
My lord, those, my lord is seeing the
4,
sorry.
3, 2, 5.
19, sorry, my lord, 19. 19.
So if it is 19,
17, 18, 19.
17, 18, 19, who's appearing for 17?
17, my lord, there is an allegation of forged certificate.
17, 18, 19, who's appearing?
Lordship is taking up
42835.
I am 13 lord.
No. 17, 18, 19.
Seventeen, 18, 19.
18, my lord, the allegation is that proper channel. 17, my lord, both uniformly brilliant career as well as post certificate.
All right, heard learned senior counsel, Mr. U.K. Nair, assisted by
MP Sharma.
MP Sharma. You are appearing in which writ petitions? All?
4325, my lord.
Only one?
Only one.
4325.
My friends would be appearing.
What about 177? Item number 13? 13. Huh?
13.
Sorry. 4325. Where is that item number?
Item
16. I'm
16.
16, my lord.
4325 is 16.
4325. And Mr. Purkasta appears for item number 15. And the respondent sides record the names of all councils.
I'm appearing for respondent number 3.
Number 3, you fill up a sheet and give it to the court master indicating the writ petitions you are appearing in.
Okay.
The writ petitions have been filed challenging the appointment of the private respondents to the posts of assistant inspector,
Deputy Director oblique Inspector of Schools.
deputy director / inspector of schools, pursuant to the selection process initiated by the advertisement number so and so dated.
Oh, my lord. My lord, the advertisement is dated 17/11/2011.
17/11/2011.
11.
Page number 28, WPC 4325, number 211. The parties have exchanged the pleadings. Matter will have to be heard. However, it is seen that the pleadings are not properly arranged. Registry is directed to arrange the pleadings properly and mark them in continuous pagination. Copy of this order be brought to the notice of registrar petition. Matter be listed for hearing again on
For respondent number? Respondent number, Rana Rano.
10th October.
Sure.
Right, yes, record matter today. Yes, record matter, may I place it today, matter before your lordship?
No, you hold it.
Fine.
We'll
Matlab,
examine it on the next date.
Matlab, that charge sheet copy, Mr. Bora
We are not
can.
making any directions. It is up to the government to produce, not to produce, whatever they want to do. Therefore, it is
I'll
submitted by the learned senior council that in the meantime, on the basis of FIRs lodged by individual candidates, an investigation was initiated into the entire selection process by CID from Assam. Stop. He submits that from reliable sources, he has been informed that charge sheet in the matter has been filed. Stop. Accordingly, the respondent, the official respondents will place before the court the status of such investigations stated to be initiated in response to FIRs that may have been filed for the instant selection process on the next date fixed. List accordingly. Names of all councils be reflected in the course list.
Much obliged.
Highly obliged.
Yes.
So this matter pertains to appointment of some Sahaya in APDCL. An advertisement was floated, and in this advertisement, it was stated that 50% post will be filled up from the open market and rest 50% will be filled up from the departmental candidate. And so far there we are for the departmental candidate, we are appointed as outsourced employee in APDCL. Now we are at one point of time, we approved before this court by stating that there are some persons who have been appointed as a departmental candidate. In fact, they are not departmental candidate. And this honorable court passed an order to hold an inquiry. And accordingly, an inquiry was held. And in terms of this inquiry, it was found that 16 persons were not the departmental candidate. And their appointment were cancelled. Now, these 16% again approved before this honorable court with an allegation that the inquiry was not properly held. Thereafter, this court entertained their prayer and directed for re-inquiry. Accordingly, another inquiry was held, and in that inquiry, it was so far the inquiry is concerned, the proceedings of the inquiry was not furnished to me. Of course, in the last occasion, the proceedings was furnished, and that inquiry it was found that no, not 16, but only 3 persons were not eligible for departmental candidate. And my lord, in that case, my lord, our case should be considered against these 3 vacancies, and as well as the other existing vacancies if so possible. That will be my limited prayer. The case was filed in the year 2015. Now, considerable time has elapsed. So my inquiry report is in hand. Inquiry report to give you. The inquiry report is not before your lordship.
What about the private respondents?
They have not yet here.
They have been served. What
My
is
lord, in
this?
fact, there is one more, a Xerox of it has also been submitted on the earlier date when this hearing was taken place. This is the inquiry report, my lord, which was been conducted after this.
So who are the respondents who were declared to be unqualified in terms of your inquiry?
Now,
No, in terms of the inquiry.
respond number
Mr. Sharma.
9.
My lord,
In terms of the inquiry, what is your finding?
my lord, may I just submit the case, my lord, before my lord. My lord, what has happened was this, after the selection 2015, my lord may just come to judgment at page 36, my lord. My lord, of the writ petition.
No, do you dispute the submissions made by
Yes,
the
my lord,
senior
I do,
counsel?
I do some
Okay. Page number
36, my lord.
36. Yes.
My lord, this was the first round of litigation that had happened, where the petitioner herein had filed a writ petition, wherein they had said that the selection process was absolutely wrong and inquiry should have been conducted. So, my lord, at paragraph 37,
Paragraph.
sorry, my lord, page 37,
Hmm.
my lord, in the year 2010, 1, 2, 3, 4, 5, 6th line, my lord. My lord, the grievance of the petitioners is that not only the private respondents, comma, namely respondent number 6, 7, 8, and 9, but several others who had not worked as casual employees of the company, or may of whom might have worked as a casual employee but did not have requisite experience, have been selected for the appointment of Sahayak. The selection of such person petitioner has alleged to denial of selection, which was otherwise rightfully due to the petitioners. The grievance of the petition in reality to is question of facts, call an independent disappropriate inquiry by the company at the appropriate level. Thereafter, my lord, the next paragraph, where the finding of the court is that with the above and in the view, the writ petition is disposed with the direction of the chairman APDCL to hold an inquiry into the matter and do the needful in accordance with law. If any of the person who has been selected as a Sahayak on the basis of quota of 50% for the casual employees of the company, such person's selection appointment, if already made, shall be terminated in accordance with law and by observing the principle of natural justice. My lord, thereafter we did the inquiry, and that inquiry order is at page 38.
Yes.
My lord, at page 39, in pursuance of the order of the Honorable Guwahati High Court, Shri B.K. Chaudhary, General Manager, Upper Assam Zone, was appointed as an inquiry officer by the Chairman and Managing Director, Assam. There are 16 persons, my lord. Considering the findings of inquiry officer, it was ordered by the Chairman and Managing Director in APDCL shall issue notice to the following 16 persons who were appointed as Sahayaks to substantial expenditure. These are the 16 persons, my lord. Thereafter, all the 16 persons in the last, my lord, at the bottom, 39, all the 16 persons replied to the show cause notice, and some of them submitted that, and as when JM and did attend work mostly on verbal instruction, they also attest some slips and signatures. At last, my lord, at page 40, the finding that considering the above in accordance with law and by observing the principle of natural justice. At page 41.
Yes.
The following services of the following 16 appointees are terminated with immediate effect. So as per the Honorable High Court's order, there was a selection of 16 appointees, and those 16 appointees, after an official order we had terminated them. Thereafter, my lord, what happened? These 16 persons who were terminated, they approached the Honorable Guwahati High Court in 2013. That is at page 44, my lord.
What was the order?
My lord, the order was for a de novo inquiry. And that is at, my lord, page 48 and 49.
All right then.
So, my lord, after doing this, we did conduct an inquiry, and that inquiry report, my lord, I have just submitted here, whereby what has, my lord, may refer to my.
Why have you not brought it on record?
My lord, I had submitted in court, my lord. In fact, this matter was heard at length last time. So, my lord, we have produced this. I've given a copy to the and also a copy to the court, my lord.
We were asking you a query. Why was it not brought on record? As simple as that. What is the difficulty? The
lord.
findings of the inquiry report.
Yes, my lord. My lord, in fact,
Anyway, so what has happened now?
so, my lord, thereafter, the finding is at third last page, my lord, 114, my lord, in page number.
Why was it sent back for de novo?
My lord, it was sent for de novo because on the aspects that some of the principle of natural justice was not followed and all that, and only under this composite that the termination that was assigned, there should be given fresh consideration. There's nothing other than
There
that.
were two writ petitions or one writ petition earlier?
Earlier, there were two writ petitions. My lord may just refer page 49 once of the writ petitions.
No, what is in 48
Yeah.
Petition was 49, it is our petition.
Page 49.
and 48?
48 was the people who, the 16 people who have been terminated.
And 49?
49 was them, the petitioner herein, my lord.
Why did they file?
They filed because
Against this 16%, our case.
their case should have been considered.
So what was the order here?
So my lord may just read, I'll just read the order in page 49. According to learned counsel, APDCL has not taken into consideration the eligibility criteria possessed by the petitioners. Beside this, termination order also have been assigned on the ground that the composite inquiry is not permitted under the law. During the course of hearing, Mr. Das Leonard Sinha agreed to the proposal of the petitioner that a fresh individual inquiry shall be carried out. Accordingly, the writ petition are disposed of with a direction to the respondent APDCL to hold a fresh inquiry individually and will take fresh decision. Such process of de novo inquiry shall be initiated within 4 weeks from today, giving due opportunity of hearing to the petitioners individually. So, my lord, this was already done by us, and thereby we have given the inquiry report.
What was the direction? What for individual inquiry for whom? For the petitioners?
For the petitioners and also for the 16 persons that were
16% is the earlier 48.
the terminated one. That's order 48. Because there's a linkage between the order 48 and 49. My lord, may I read the order 48 here, my man? The petitioners had appeared before APDCL for appointment as Sahayak. However, the petition was not selected by the respondent, hence this writ petition. Today, some other writ petition arising on the same selection process has been disposed of by this court, directing the APDCL to hold fresh inquiry whether the other petitioner's selection was correct and valid. Until the claim of some other petition is decided by the concerned authority, there can be no mandamus for the High Court. Certainly, if the other petition appointment is found to be illegal, there will be vacancies and respondent may consider a claim of the present petitioner in the resultant vacancies. These are the present petitioners.
Huh?
In view of the above, the petitioner are directed to submit the
No,
representation.
Mr. Dasgupta says 49
No,
writ
49
petition.
49 is the 16 people, 48 is there.
48.
48.
Yes,
All right.
that is why they had to ask to give a representation. So, madam, may allow me to take to the inquiry report that I have
Yes.
submitted, madam.
Yes.
At the third last page, madam, of the
Multiple.
findings. Page number.
Page number 114.
114, my lord.
Yes.
During examination of various documents pertaining to the selection process of the Sahayak, it is found that the entire selection was based on a memo dated so-and-so, issued by so-and-so, which has been further confirmed in the written statement of the chairman of the selection committee, kindly be seen at Annexure 8. The said memo, besides giving age limitation education, also directed the application of so-and-so. Then, my lord, thereafter, during scrutiny of a second page, my lord, 115. During scrutiny of the grievances of the petitioner who have filed writ petition before the Honorable High Court, the main grievance of the selection was not done as per the formulated policy by the company. Perhaps in this context, they are correct as explained above, but at the same time, it's also to be noted that total 426 applicants, the scrutiny committee cleared the candidature of 408 number of candidates were allowed to appear in the physical and practical tests, of which the selection committee cleared the combined list of 142 numbers of candidates for the post. It is also a fact that all the candidates more or less have the same category of eligibility for the said post. However, the specific name of the candidates whose names are referred in the WPC for the non-eligibility for selection are placed in Annexure 27, and all the available records have been examined thoroughly. Further, in course of the direction of the Honorable High Court, Sri Vikas Kusum Chaudhary, the then GMA, conducted an inquiry. On the basis of his inquiry altogether, 16 number of candidates were terminated from their service, details which could be seen in Annexure 28. It appears that the ground given by the inquiry appears to be justified in case of candidates who were terminated having no experience as Sahayak, as already explained above. The particular condition of requirement of experience as Sahayak work was not mentioned in any of the direction issued by the selection committee, nor by the chairman himself. Secondly, the continuity of service of the existing workers for not less than a minimum period of 3 years found to be very confusing. It was not followed on principle as explained earlier. In this regard, statement of chairman of selection committee clearly indicates the person having experience of work in the company for certain period was considered as a criteria for eligibility, though no written instruction have been issued in this regard. Moreover, It is to be pointed out the candidates who have a poor section of the society living hand and mouth. And then on this ground, it would be inhuman to terminate their job. Therefore, 16 numbers of candidates except Sri Dushman Datta, Rajiv Konansira, whose documents would be false, the remaining terminated case may be considered. So out of the 16, three people were left aside, another 13 were absorbed. And that's what we have relied in the affidavit in opposition. Now the case of the petitioners are also being considered, but they never came into the zone of consideration.
Why?
My lord, that is their reflection is there, my lord.
Why they were not considered? There were 3 persons not whose
Yes, my lord.
documents were found to be false.
Yes, the 3 persons, my lord, may furnish my affidavit in opposition, my lord. One. Order number 12, 2015, my lord. After the inquiry, we pass an order.
Page 19.
Page 19, my lord.
90.
119, my lord. There was no running page number.
190, this bunch.
Affidavit, no, my lord. Affidavit in opposition that we have filed. After the inquiry office, we gave a report, my lord. We filed an affidavit. Annexure 3, my lord. Running page number will be 71 perhaps.
12 March.
Yes, my lord. 12 March 2015, my lord.
Yes.
Peruse the Honorable High Court order dated so and so, passed in so and so, and office order dated so and so, pursued the inquiry report dated so and so, submitted the inquiry report. These are all the judgment that has been passed by the Honorable High Court. Thereafter, after going to the inquiry report, facts reveal that the office memo number so and so issued by the then CGM APDCL prescribed with the condition that the eligibility criteria is not restricted to temporary workers engaged in Sahayak only, but is kept open to the other temporary also, in case they have rendered minimum of 3 years of service. All these ad hoc workers who are eligible as per prescribed norm were considered eligible for interview. I have carefully examined the findings of the inquiry officer and grievance of the writ petitioner in detail. And considering all the aspects, I came to the conclusion as follows. None of them were engaged against any sanctioned post. All the workers engaged in the inherent interest of the company on ad hoc basis. Therefore, they do not have any legal right to claim a regular appointment against a sanctioned post. However, considering the work experience of the following 13 persons, and since the selection committee recommended them to be suitable for the post of Sahayak, they may be taken as fresh as Sahayak on humanitarian ground. My lord, thereafter. On C, my lord.
Who are these 13 persons?
These are the 13 persons, my lord, which were rejected by the Honorable High Court. However, after the inquiry, due to the suitable condition not being matched, and there was with discrepancies with regard to the type of selection, we appointed them by the office order. Now, report reveal that the prayer of the following 2 persons are not tenable as the candidates are not bona fide and do not have any local standing for claiming the post. Therefore, the candidates have been cancelled.
This inquiry report,
My lord.
order is pursuant to the inquiry report.
Yes, madam. This person in the order. Inquiry report, my lord. Inquiry
In the
report was,
inquiry report, you have already held that there are 3 or 4 persons whose documents are found to be not genuine.
yes, my lord. Those 3 persons we have already removed, my lord.
You remove.
Yes, my lord. At page 20, my lord.
And then
On the 13 persons, we have actually followed what the inquiry officer has said. The inquiry officer has said in its report at page 115 that it is pointed that it appears that the ground given appears to have not justified in the case of candidates
You're
who are
reading
terminated
from-
having no experience.
you're reading from which page?
My lord, my inquiry report, second last page, 115 page number.
115 paragraph?
My second last paragraph, my lord.
Yes.
It appears that the ground given by the inquiry officer appears to be not justified in case of candidates who were terminated and having no experience as Sahayak, as already explained above. The particular condition of requirement of experience as Sahayak work was not mentioned in any of the direction issued by the selection committee nor by the chairman himself. Secondly, the continuity of the existing workers for not less than a minimum of 3 years found to be very confusing. It was not followed on principle as explained earlier. In this regard, statement of chairman of selection committee clearly indicates that a person having.
So what is the
experience-
sum and substance of all that?
My lord,
very longish
therefore-
order?
my lord, therefore 16 number of candidates,
Hmm.
except Sri Dushman Datta, Sri Rajiv Khanikar and Sri Rafiqur Rahman, whose documents are found to be false, remain terminated, case may be perhaps be considered.
Hmm.
So this inquiries officer said that out of 16, you can consider the 13 people because, but the other 3 you cannot. So we did accordingly. The Honorable High Court directed us to do an inquiry. We did an inquiry. As per the inquiry report, the inquiry,
Now what is under challenge in this writ petition?
they have not challenged the inquiry report.
You have not furnished them, how will you challenge?
My lord,
You have to
This-
furnish them a copy.
my lord may just see their prayer once, my lord. My lord may just,
You'll have to furnish them a copy. Yes, what is their prayer?
at page 12, 13, my lord.
Yes. Relevant records.
Yes, my lord. The respondent shall not be directed to produce all pertaining to reversal of earlier inquiry whereby the privates were declared unqualified candidates appointment Sahayak in Assam as departmental having 3 years of experience that I have already read out to you, my lord. Appointment of respondent number 7 to 15 made by reversing the earlier finding of inquiry declaring them to be not eligible for appointment in departmental quota shall not be set aside and quashed. Subsequent inquiry proceedings to be produced by the authorities of Assam PDCL shall not be adjusted and declared as illegal and inoperative. The said inquiry report which I have read out to you. And that the petitioner who appeared in the requirement process of Sahayak as a department candidate with requisite experience of 3 years shall not be appointed as in the.
So which prayer do you think is not
My
alive
lord,
today?
the first 3 pairs, my lord, the entire exercise of this Honorable High Court direction was to do an inquiry. We did the inquiry, and after the inquiry, we found that the 13 persons can be taken up and 3 persons have left. But my lord, they have nowhere in their writ petition have stated that how does they come into the zone of consideration? That we should take,
We don't know, but that is what the order of the court said earlier.
no, my lord, the order of the court said about the being inquiry, and we did the inquiry.
Uh,
And that's why our office order.
After the
clearly reflects-
inquiry, if there are any vacancies,
Yes,
now at least there are 3 vacancies.
my lord, this,
Out of 16, you have terminated 3.
absolutely, madam.
So there are 3 vacancies. So in terms of order at page 48, at least 3 persons will have to be considered.
My lord, they are not, there are 12 others, my lord. There are 13 persons here. madam.
Huh?
There are 13 persons, the petitioners.
3 you consider out of 13 for the time being. That's what the order said, page 48. It was an inter-party order.
My lord, the order said that to inquire fresh individually and take fresh decision.
And
With-
if found
And,
to be illegal,
and such process is deemed shall be initiated in 4 weeks from today, giving due opportunity of hearing to all the petitioners individually.
no, page 48.
My lord, in view of the
Before that,
if the other petition appointment is found to be illegal, there will be vacancies and respondent may consider.
Hmm.
It's not, it's word may, my lord, not shall.
Have you considered?
My lord, we have done an inquiry with regard to that required.
No. You, perhaps my reading of this order may not be correct, but the order says, in case you find there is some illegality,
Yes.
there are vacancies. And the respondents can consider the claim of the petitioner in the resultant vacancy.
My lord, with that regard, my affidavit, my office order clearly states that the petitioners. My lord, I just read out to you. I have carefully examined the finding and the grievance of the writ petition in detail and considering all the circumstances come to the conclusion as follows. None of them were engaged against any sanctioned post. My page 19, that my office order with regard to the petitioner. So if my lord may give me if my lord directs that we may consider to consider them, my lord, then an office, then we have to give it, they have to give a representation, then we have to take into consideration. Again, the same process.
This is already an order of the court.
My lord, that we have already taken into effect, my lord.
You are referring to which page
Page 19, my lord,
of
my affidavit in opposition, my lord.
your affidavit? Yes.
I have carefully examined the finding of the inquiry officer and the grievance of the writ petitioner in detail, and considering all the facts and circumstances, come to the conclusion as follows. None of them were engaged in any sanctioned post. All the workers engaged temporary interest of the company on ad hoc, therefore they do not have any right to claim of regular appointment against the sanctioned post.
No, whose case are you referring to?
The petitioner's case, my lord.
Where is it reflected?
My lord, grievance of the writ petitioner in detail. And my lord, and the details of it is reflected in the inquiry report, where we have given notice to all the individuals at page 81. '84, my lord. Name of the petitioners whose statements were recorded during inquiry. Internal page number 84. Name of the petitioner whose statements were recorded during inquiry, my lord. Here, my lord, the petitioner's name has also been there.
The findings of the,
Madam,
so what
please,
is the ground of rejection? That they were not engaged in any sanction post?
My lord, may you just see page 81. Prasanna Bhuya, my lord, the present petitioner, had work experience Bilkar, but no
No, no, come
experience.
to page number 19 of your affidavit.
My lord. Yes, my lord.
Page number 19,
Yes, my lord.
come to the 1, 2, 3, fourth paragraph.
My lord.
The
Right.
fourth paragraph of the order.
Yes, my lord. None. I have carefully examined the final inquiry and the grievance of written detail and consider all the facts and come to a conclusion as follows. None of them were engaged any sanction post. All the workers engaged in the interest of the company on ad hoc. Therefore, they do not have any legal right to claim for regular appointment against the sanction post.
So what is the ground of non-consideration of the petitioner's case in terms of this order?
My lord,
What grounds?
that is there reflected in the inquiry, my lord. That is what I'm saying.
Inquiry report, come to page number 115.
My lord.
Inquiry report says that this continuity of service for not less than 3 years found to be confusing. Inquiry report was of the view, inquiry committee was of the view that termination on the ground of lack of this 3 years
Yes,
is found to be inhuman.
yes. That is why 13% should be considered whose documents has been in that regard.
Correct.
So, my lord, now, my lord,
Now assuming you had 16 persons.
my lord,
Out of that, court say, the inquiry said, okay, 3 persons found to be forged, fabricated documents, terminate them, rest, 13 persons, keep them. Now, there are 3 resultant vacancies.
my lord.
Now, these 3 resultant vacancies, are they not required to be considered in terms of the order at page 48?
Yes.
That is what the order said.
My lord, absolutely agree with my lord, what my lord has just also stated. My lord, but while this inquiry had happened, we had also given a notice, and this inquiry report also contained why these people are.
But this inquiry report does not say that they are not fit to be considered. Where does it say?
So, my lord, in that view, my lord, and I would.
Your order, the order at page number 19 of your affidavit also does not say that their documents are forged or they do not fulfill the criteria. It accepts the inquiry report. Is that your case, Mr. Dasgupta? Okay. That you will have to consider because there is an order of the court.
My lord, in that case, my lord, because already the 13 persons that they have taken a respondent, they have been already serving. And there are 13 petitioners herein. So my lord, in that case, if my lords, what are my lords? have
We
suggested-
don't want 13%. We are just interpreting the order at page 48.
My lord,
48 says after going for de novo inquiry, if you find anything illegal, and if there result in vacancies, then the respondents' cases should be considered.
may be considered, my lord.
May be considered.
May be
All right,
considered.
maybe.
Yes,
Your inquiry report said out of 16 persons,
13.
13 valid,
Yes,
3 invalid. Now against those invalid, which are the resultant vacancies, the petitioner's claim will have to be considered in terms of the order at page 48.
My lord, in that case, my lord may say we have to file a representation and when,
What representation?
because there, my lord, there are 13 petitioners herein, my lord.
So
So my lord, then who, out of the
it
13
is for you to decide out of 13, how many from three, how you are going to select. Why do you want a direction? The direction is there at page 48. You have conducted de novo.
Yes, my lord.
There are resultant vacancies, but you did not consider the cases of the petitioner.
My lord, the cases of the petitioner were not fit. That is what the inquiry report stated, my lord.
No, it did not. No, it does not. You read the findings. There is no clear finding. There is no clear finding. If I have misread something, you point out.
Sure. My lord may just reflect page 84 once, man. My lord, from serial number 26 to 40. Name of the petitioner whose statements were recorded during the inquiry. At top, my lord.
Yes.
And these are the same petitioners, my lord, who are here.
So tell me one thing, this page 48 order is of whose order is this?
So
In respect of whose case?
page 48 is in the case of them, my lord.
So
The-
they filed their, what is their writ petition number?
Their repetition number is at their repetition number,
That's page 44.
yes, page 44, my lord, that is 1221,
So
2013.
you're referring 26 is not 1221. 26 is 4322.
My lord, I'm talking about the petitioners herein, my lord, the petitioners who have
No,
filed.
before that, I'm asking you, this order at 48
Yes, my lord,
was passed in a writ petition
yes, my lord.
in which the present petitioners were petitioners earlier. Is that what? 11, 12, 13. Who are these petitioners in at page number 44?
আপনার petition number কি আছে? 1221.
1221 are number same petitioners, man.
Our petition to the level.
My lord is, the petitioner's names are not matching with the one with 1221, my lord.
No, they are not matching in seriatim. If you look in carefully, you will find the names there.
Miller, initially we filed this case numbered as 4322, 4322 of
Page
2011.
number 45,
Yes,
petitioner at serial number 12
Yes, sir.
is the petitioner number 1 here.
My lord, it is the same petitioner, Ratul Surya Govind,
Then-
was there. Yes, The case number is 4322-122-1 2013.
Yes,
The same writ petitions, my lord.
correct.
Yes.
Not the same writ petition. It is the earlier writ petition,
Yes, earlier.
1221. 1221 at page 44 is the earlier writ petition.
My lord, I just rephrase what I'm trying to say, my lord, is this, that my lord, after this order of 5732 and 6/12/2013 are combined, my lord. And after this, these are the sections of people who had filed a common writ
So
petition.
you show us the list of writ petitioners who are named at page 84. Where is 1221? There's some other number is written here, 433, 4322.
The 4322 was first case. that we
First
have filed.
case.
First case, that your lordship will find.
At page 34, 32, my lord. 4322.
Hmm. So
Page 32,
32,
4322 of 2011.
yes.
And pursuant to this case, my lord, these 16 persons were terminated. Then, my lord, we approved before this case, and our case number is 1221. Next case. They also came with another application.
All right. Let us take 4322 also. Then
1221. Second case. Well, yeah, we have filed 3 cases.
the findings of the inquiry committee does not say anything negative about them.
Yes. There is nothing about us.
Which has been accepted by the
Inquiry officer.
inquiry officer. Which has been accepted by the employer. Yes,
My lord, we comply with the order, my lord, as because we have taken everything in consideration.
no, you did not comply with 44 order, 48 order. 48 order will also have to be complied with. The resultant vacancies. 3 vacancies at least.
My lord, in that regard, my lord, I would just say, my lord, and we may consider the 3 cases, my lord.
You consider?
No.
Yes,
Don't have any other prayer like that, listing. Though we are number of petition is 13, let them consider against these 3 vacancies. If possible, some existing vacancies are.
so
there,
the direction can only be for consideration of 3 of the petitioners.
only against 3 positions here. 3 posts. Let them consider our case against these 3 posts. And if
You are not
possible-
putting to challenge this inquiry.
Actually, inquiry report was furnished us only on that day. On the last hearing. That in pursuant to the order passed by this honorable court. This honorable court has also passed an
So
order.
pursuant thereto, but now you have got a copy of the inquiry
Yes.
report.
Now,
So you have
in
not,
the year 2023, Miller, we have got this copy.
so you are not putting it to challenge.
8 years has elapsed already.
Hmm?
12 years has elapsed from 2011 to 2023.
My lord, they could have been, when
We have no
RTI,
difficulty closing it. We are just asking you as we understand, the options are that out of the 16 vacancies, 3 are available. So your cases can be considered, but only for 3 persons.
Let them consider this.
All right.
And
Okay. We'll pass orders. Just go. we are holding on to this inquiry report till delivery of the order. At disposal. Yes, Mr. Das.
No, item 20, some urgency is there. On learned 20 is also there. He says that it can be taken up on Thursday, subject to what your lordship is.
Thursday. I think some matters are fixed. It'll be listed on Thursday. If possible, we'll take it up. If possible, we'll take it up.
Dismissal from service, my lord, so some important detail. Let it be on Thursday, we'll pray again.
Thursday, item 20 on Thursday.
Lordship, I have a similar prayer for item number 23, 24, and 25. I am for the petitioner in that matter. Matter relates to pay protection. May I pray the matter will be listed either next Thursday or on 26.
It will come as per the
My
dates
learned
given
friend-
by the registry.
I understand. My learned friend is appearing for the department. He has a personal difficulty on other dates. That's why.
Oh, we'll requisition his personal calendar and fix dates according to his availability.
No, no.
You give us a date, what
No.
can be done?
Well, on 19 or 26, well, it might.
See, there's no difficulty listing matters. But the request would be to be precise with your arguments.
Yes.
And the whatever case laws you want to rely on,
Yes.
it doesn't take much time to
Yes, well, I understand.
conclude a hearing.
Yeah.
So
Item number 26.
it will come up according to the roster given by, the dates will be
Yes.
given by the court master, except for item number 20.
So I also pair, same pair for item 21, lordship.
Ah,
That will be listed on 26th of September, lordship.
you'll see,
2016
the
matter,
dates.
lordship, because I
the
have.
dates will be given by him. He is not only the court master, he is the date master also.
It must.
If it is not inconvenient, 26th.
Also, my lord, same prayer, my lord, 26. my lord. Because already review has been done, my lord, dismissed, petition allowed, my lord, read file remain back again, my lord.
You give the date.
29, not by your lordship, my lord.
Huh?
29,
Why?
because the lordship on last occasion, prior to the last order. Not by
29 to some?
No,
29.
no, correct.
Order लिखा है.
Regular bench.
Order लिखा है.
29.
Yes, my lord.
29.
It is regular bench.
Prior to the last order. your lord. That's it.
What is the matter about?
Petition was allowed, my lord. Review petition also dismissed, my lord. Filed by the respondent, my lord. Thereafter, remand back the matter.
We don't know, it says before any other bench without me.
That's what.
See, my honorable Chief Justice order is there, my lord.
Huh?
To take up in regular bench, my lord. There is a only first phase.
Order है ना. Regular bench.
Is there any reference of a writ appeal order? Yes.
Yes.
That is the reason.
Oh, lordship was there.
That's right.
Sorry, I'm sorry. my lord.
And
Regular-
Because of the
Mm-mm.
I had to point out for any other bench. Yes.